My lord, two matter, my lord, definitely listed on my lord 7th of month. One is for orders, one is for admission.
Next week it's not possible. We are already packed. We have it on 14 June.
Then my lord on
14 June.
14.
Yes. Wednesday.
Master.
May I please, Your Lordship? Pertaining to item number 18, Your Lordship, SSA for I'm appearing for respondent number 9. Here, Your Lordship, on the last dated order, Your Lordship, it has clearly mentioned that if we are failed to produce the instruction, Your Lordship, then and there personal appearance would be needed, Your Lordship. But today we received instruction, Your Lordship, but personal appearance has been shown. So, Your Lordship,
We have to see the order. 15.
Seventeen 5/2023.
You have the instructions.
Yes, Your Lordship. Instruction received.
You have adequate instructions.
Yes, Your Lordship. Deeply obliged.
Both the matters.
No.
18.
18, Your Lordship. I am appearing for Your Lordship. Item number 18, respondent 9.
What about 17?
17 on the way of it. The original record is not successful. 14 letters. So he has got some other record.
17 is not connected with 18.
No. 17 is they are out of it.
We'll see. Coming from where? Yes.
My lord, in connection with the item number 40 and 41, my lord, I have filed an additional affidavit, my lord, to bring on record the order passed by the deputy commissioner.
Yes. What was this matter? Competition department.
No, my lord, it's regarding cancellation of my wholesale PTS license. Deputy commissioner has, my lord,
PTS license. Why have it come here? For what matter?
yeah, lordship, it was heard, and in the meantime directed to consider my appeal by the deputy commissioner. Then in the meantime, deputy
Okay, you bring it on.
I'd like to mention one matter for withdrawal on Monday.
My lord. Writ petition pertaining to this bench. Writ petition of bench 2. Writ petition of bench 2. Yes,
My lord, with the consent of the other said matter. My lord, item number 31.
31, yes.
My lord, instructions are awaited to file a petition, my lord. Let it be listed after 2 weeks, my lord, any day, my lord.
Taking the consent of the
Yes,
other
my
side.
lord.
21 matter. Get the instructions.
31, my lord.
No. 21 matter.
Yes,
Get
my
the instructions on the prayer of Sri S.R. Rava, General Counsel for the BTC. Matter stands adjourned by 3 weeks to enable him to obtain the instruction.
Highly obliged.
Is there any interim order?
No, there may be.
List on 26th of June.
Listing matter, can you take next?
Matter of which year?
Matter of 2022, first of January,
Matter regarding what?
regarding contempt.
Contempt. When was it last listed?
Sorry, madam.
When was it last listed?
Last listed on 26/4. 3 weeks time was granted, but deals is over. Madam. There is
No,
nothing.
yes.
Any date, my lord.
Contempt we are not allowing mention. Yes.
My lord, I wish to mention for listing a matter of 18 matter, my lord, 2018 matter. It was last listed on my lord 17/11/2022.
Matter regarding?
Matter regarding non-payment of salary, my lord.
You will have it on 14th.
Obliged.
Yes, madam.
My Lordship, I beg to mention for listing in order. Matter was last posting 24 January 2026. Kindly list the matter on
Matter of which year?
promotion
Which year?
22.
Matter regarding?
Promotion with respect to service on officer.
There is no urgency as such. Have it on 16th of June. 16 June. Yes.
Lordship, I beg to mention item number 9. But it relates. It's a rule challenging matter. So it may be listed in division yes, along with WPC number 2447 of 22.
Your name?
Lordship, A. Setia.
You're instructed by Mr. Nair.
Yes, yes, yes.
Sri A. Chetty Alliance Council on instruction, appearing on instruction of the UK and Ireland Senior Council, submit that the virus of a rule is the subject matter of challenge in this petition, and accordingly, this should be listed before the appropriate bench. If further submits that a similar issue is pending before the Honorable Division Bench in WPC 2447/2022, para register to verify and list this case before the appropriate bench.
Highly obliged.
May I please, Your Lordship. My lord, I beg to mention item number 49 matter. Is a
49,
motion-
yes.
49 is a motion matter matter. Stated as my lord order.
Contempt matter.
Contempt matter matter.
There is some direction to have contempt in the order column. We'll take it up as motion. Don't
My
worry.
lord,
Yes.
highly
Please,
obliged.
Your Lordship, I beg to list in contempt matter. Your Lordship, it was last listed in the month of April, on 3rd of April, Your Lordship, and it was supposed to be listed after
You're for whom?
for the petitioners, Your Lordship.
Contempt, what is the urgency in a contempt matter, madam?
The petitioners are seated, qualified, and they have not received the appointment letter.
Contempt, you are not allowing information. Yes.
I make a mention for listing on WBC Lordship. A matter relating to the appointment of SMBC President Lordship. It was a by order.
Is it
fixed
a
on-
motion matter?
No Lordship. It was a admission Lordship. By order, it was fixed on 28th April Lordship, but not listed. Subsequently, we have make a mention, and it was fixed on Lordship 12 May. Lordship, that was also not listed. May on Tuesday Lordship, I am praying for listing.
Have it on 14th of June. Next week we're
14th Lordship.
14th June.
My lord, I beg to mention item number 10, my lord.
10.
So there is some clerical mistake, my lord, only my lord, designation has not been done properly. my lord.
Do it.
May I please, Your Lordship, my prayer is for listing Lordship, 2 WPC, both are 20 matter Lordship, for admission Lordship. One is the salary matter, another is the pension matter Lordship.
Pension will have it on 12th, the salary on 16th. Okay.
12,
Pension, the matter will have it on 12th of June,
yes, Lordship.
and salary matter on 16th of June. Okay. Victoria?
I have for the withdrawal of the WBC 900 of.
So we had granted you time to have instructions.
Yes.
Do you have any other instructions?
No, no. Already he has been kind of.
Third to be story, learned counsel for the applicant petitioner who has filed this application with a prayer for withdrawal of the connected WPC 900 of 2018. You are appearing for whom?
I'm for opposite party number 7, respondent number 7, private respondent.
Also heard the SMT 60 standing council. Secondary education and your Roman.
I for
Your IH Borby and three IH Borby learned council for respondent number 7.
7.
Who does not object to the said prayer? Petition. The petition accordingly stands dismissed on withdrawal. I stands allowed. Right in both the cases.
Obliged.
please, Your Lordship.
Withdraw.
Given, I withdrew. I want to withdraw it with the liberty. There is a serious mistake done, but there is-
Yes, Mr. Chisti,
Yes.
have you seen the last order? It was pointed out before this court that there was nothing on record to substantiate his claim.
Yes.
He wants to withdraw.
He want to withdraw, Lordship.
Withdraw. Assembly Secretary Council. Quickly, but
Obliged.
देखा ये तो लोग समझ लेंगे बस ना ये एक नंबर तो complete है we'll have item number 1 after the motion.
Only to Lordship, my prayer is that item 42 may be taken a personal appearance. The IS Morigaon is present, Lordship. He was
42 is what content
is a contempt matter, Lordship. He was asked to appear because he has after receiving the notice, he has directly written to the REC. That is the fault, Lordship. And now I am appearing, I will file affidavit, Lordship.
Yes, let us see 42. 42, let her wait for some time.
Yes, sir.
We may not give privilege.
Yes, sir.
Yes, motion.
Yes.
Item 2. Motion, motion.
17.
Mr. Deka will have this matter after the motion. Your matter will take some time.
And I have a
May I please, Your Lordship? The petitioner before your Lordship praying for provincialization of his service as a Assamese language teacher. The petitioner was appointed in the year of 2000 Assamese as a language teacher, my lord. But at the relevant point of time, he has no qualification of Assamese subject. He has no subject in the Assamese in the SSLC examination.
You filed the additional affidavit.
Lordship,
Have you filed the addition?
No, I did not file any affidavit because I did not get any instruction from the authority. Because, my lord, the petitioner claiming for provincialization of service under.
Now, have you seen the last order?
Yes, sir.
Second last paragraph. In view of the above, petitioner is allowed to file an additional affidavit, explain the reasons as to why he has to be considered for provincialization as paid by him in this petition. So here he did not have the eligibility to be appointed. You have to file an affidavit.
Yes, my lord, then I will file an affidavit.
File the affidavit.
Yes, sir.
Though this matter has been listed for motion, it transpires that the additional affidavit, which was directed to be filed by the order dated 21/11/2022, is yet to be filed. Sarah, MSA Buzar Barua, the counsel for the petitioner, prays for and is granted 3 weeks time to file such affidavit. Please for motion after 3 weeks.
In item number 3, I am appearing, my lord. Then the petitioner is paying for provincialization of her service as a music office service as a music teacher. The petitioner school was provincialized in 2013, my lord. And thereafter, again petitioner has approached before.
The matter before the division bench is over.
Those matter which is pending before division bench, their last appearing in the SSLC examination was less than 10. But in this case, the petitioner school, their last appearance, my lord, like to kindly see the annexure 13, page 37, 10, 2014 last
But
appearance.
how do you overcome the observation of this score on 3/4/2023?
That was on that day. I am not appearing. My junior was appeared, and he could not submit the.
even then, Lordship, let the division bench take a decision, Lordship. That cases may be.
But in rule, my lord, in the rule 3(6), there is a clear
But,
direction.
are those matters before the division bench still pending?
Yes, Lord.
Yes, but
Yes.
those cases who have less than 10 last appearance.
See, those cases are different from your case.
Yes, my lord. In my case, in 2014, there are 10 numbers of students appeared in HSLC examination,
What do you say, Mrs.
That I'll have to
2015.
verify, Lordship, because I don't have know that.
We'll have for motion next Wednesday.
In next meeting.
You have verified.
Yes, yes.
Yes.
Though this court by order is 3/4/2023
In number of-
had directed listing of this case after resolution of the issue by the Honorable Division Bench, before whom the issue was pending, MS Buzar Burua, the learned counsel for the petitioner, has submitted that the facts of this case are different from those cases which are pending for the Honorable Division Bench, and this aspect of this matter could not be properly explained to the court on the last occasion. Pre-SR Standing Council, Elementary Education Department, however, pressed for some time to obtain instructions in this regard. List for motion on Wednesday.
आपला तो number भी नहीं.
May please, your lordship. Lordship, may kindly pass over this matter for the time being.
Timing is not possible. Motion matter, why timing?
Lord, the conducting counsel, Mr. Espotam, is on elected court to one matter.
And
What is the
this a
matter
case-
about?
This is a case notice to roll, Lordship. The petitioner case was not commissioned because her name found to be different, Lordship. Earlier, she was included as Deputy Doctor. After marriage, she has transformed to her name to Deputy Hazarika.
No, this is
So-
a case of provincialization
Provincialization,
under
okay.
17 Act.
Yes, Lordship. Earlier, she was deprived from the commission as per earlier Act 2011 Lordship, in 2013 Lordship.
Your name? PH? H core. You're not on record. R3 H core, Learned Counsel, appearing on instruction of 3 as Botakur, Learned Counsel for the petition. Full stop. The grievance of the petitioner is with regard to provincialization of her services, which she has been discharging as a science tutor in the Bhim Kothar Bapuji High School since the year 1994. The petitioner it is submitted that after her name, due to the change in her surname, after her marriage, due to the change in her surname, the confusion has probably arisen. Issue notice. So issue notice.
Yes, yes.
Issue notice returnable by 4 weeks.
And for 123.
Pre SMT District or Understanding Council. Elementary
Yes, Lordship.
Elementary Education Department accepts notice on behalf of respondent 123. 5 district level. Shri SR Boro, London State Council for Respondent 5. Sarva Shiksha. Anyone who's there otherwise?
Beep Chaudhary, he was here. He was here, Lordship.
B. Chaudhary for Respondent 6. Sarva Shiksha. And the National University for Education, Training and Administration. Ministry of Human Resource.
Lordship, central government.
CGC, any CGC? Anyone CGC? Central government? Who's there? Otherwise, whose name can we record? You are there, CGC. K. Fukan. for respondent number 7, CGC for respondent number 7. That extra copies of the writ, that extra copies of the writ. Right.
Only lordship name of SSA and CGST may be shown in the
Ah.
call list, lordship.
Cause this to reflect CGC and ST SSA.
4 weeks.
Yes,
Yes, sir. But the impugn order, the second round of petition, impugn order dated 6/2023, my lord, whereby the claim for provincialization of rejected on the ground that the one committee has been constituted and that committee has prescribed certain criteria with regard to incorporation of the name in the dice code, my lord. But as per the law, my lord, there is only two committees. No other committee can be constituted. Only district level committee and the state level committee, my lord. No other committee can be.
be forecast learned counsel for the petitioner who is aggrieved by rejection of his case for provincialization of service. Full stop. The petitioner claims to be the first assistant teacher of the Sarva Mongola Venture Lower Primary School in the district of Kachar. Full stop. However, his rejection is as per recommendation of a committee which is not contemplated by law. So, para issue notice returnable by 4 weeks.
And for 1, 2, 3, 5, and 6, lordship.
1, 2, 3, 5, and 6.
1, 2, not the, my lord.
1, 2, 1, 2, 4,
1, 2, 4,
and 6. No, 5 also. Deputy
Five,
Inspector.
deputy inspector. Yes.
1, 2, 5, and 6. SR Bureau for 4.
Four.
SR Bureau for 3.
3.
3, lordship.
Extra copies.
But sentence cannot be barred for demonstration of the
This is.
Do not, does not be required. Let us see the instruction.
My lord, instruction was sought for my lord, but the instruction was sought for my lord, but not received, my lord. We need further time, my lord. Or
Get the
my lord,
instructions for, can we issue notice?
yes, my lord, notice may issue.
You are agreed by your marks secured in SMS paper.
Yes, Lord. Mark has not been able to take it.
Wrong entry of marks since was marks given or not? Did you have SMS paper?
So, Lord, there is no wrong. That mark answer has not been evaluated.
Marks given or not?
No mark.
Marks not given at all in SMS paper. H. Bezurwa. Hard to H. Bezurwa learned counsel for the petition who is aggrieved by the action of the SCBA in not allotting any mark in the Assamese subject, which was one of the papers of the petitioner who had appeared in the HSLC examination 2022. Let notice of motion be issued, returnable by 4 weeks. Shri D.K. Roy, standing counsel. No, first you write education secondary, SMPC for 1, D.K. Roy for 2, 3, 4. What about the controller of examination?
My lord, I am
2 to 5, sir.
2, 3, 4, and 5.
Extra copy tomorrow. Not by Monday. I will get by Monday. Yes.
Regarding completion appointment, I applied for the completion appointment in 2004. My application has been placed before the DLC in 2011 and rejected on the ground that 2 years passed. That means probably the principal 10 is applied. But in this case, principal 10 has not been applied. The 15 is not placed earlier. Forward by
When did you apply?
8/3/2004, your Lord. Yes, 50.
And when was the death? 17-2.
2004. Within the time.
But the rejection was when? 2011.
2011.
What were you doing all this time?
But if I was not aware about. I have approached the respondent. They have not provided a copy of that.
But you applied in 2004 and you wait till 2023.
Respondent should have communicated as per.
Respondents should have communicated, but what prevented you from coming to the court?
After 12 years.
What are your reasons?
I have explained your lordship,
Where's the
8 years.
when was this provided? Paragraph 6. You have not said when was this provided? 17/9/2011 resolution.
Hello.
When was it provided to you?
Very recently, your lordship,
When?
last month.
Where have you stated?
Recently, the date is not. But your lordship, as per provision of 24D of the OM,
Provision will come in the code, but this is an equity code. Where is your conduct? We're not entertaining. Notice is not a matter of right, Mr. Counsel. You have to make out a case. Your P. Rahman, P. Rahman, learned counsel for the petitioner. Also heard three. S.R. Burwa. Also heard MS. You're for whom? Education. Also heard MSK Das, learned standing counsel. Elementary Education Department. And Sri S.R. Burwa, the learned state counsel. This writ petition pertains to a claim for appointment on compassionate ground. Para, the fact projected in the writ petition is that the father of the petitioner was a head teacher of number 1864 Dokhin Khandakarpara LP School in the district of Borpeta, who had died in harness on 17/2/2004. Also, the petitioner claims to have filed an application for consideration of appointment on compassionate ground on 8/3/2004. Also, the petitioner claims that however, the state application was rejected by the district level committee in its meeting held on 17/9/2011 on the ground that 2 years have passed from the date of filing of the application. Also, while the case of the petitioner is that such rejection is in conflict with the office memorandum date 1/6/2015, what intrigues this court is the long and inordinate delay in approaching the court from the date of filing of the application. Even assuming that the rejection, that the reasons prescribed in the meeting dated 17/9/2011 while rejecting the application can be matters of adjudication, even from that date, there is a delay of about 12 years, which has not been properly explained at all. Full stop. Para. The entire objective of the scheme for appointment on compassionate ground being to give immediate succor to a family which has lost the sole earning member, comma, the said objective does not appear to be present in the instant case. Full stop. It is further a settled law that appointment on compassionate ground is not a mode of appointment, but an exception to the general rule. And the inordinate delay in the instant case does not entitle the petitioner for any equitable relief under the jurisdiction of petitioner collection rejected. Yes, next.
Hello,
Obliged. Yes.
Here, Your Lordship. Is the improved combination lordship.
Termination.
Yes, Your Lordship. Page 75, Your Lordship. Without any prior so-called notice, direct violation of Rule 15 of the law, National Justice, Your Lordship. Termination is at page 75, Your Lordship.
How is the Union of India connected?
Your Lordship. This school is affiliated to CISC, Your Lordship. We are not the Ministry of Limited.
Affiliated.
Yes.
So you come to the writ court against a private school.
I have taken some judgment, Your Lordship, where even in the case of a private school, where perform
Are your remedies barred under the civil law?
civil law, Your Lordship. I have controlled many judgments, Your Lordship.
The
where
question
there
is, don't you have any other remedy under the civil law?
civil law, there is no tribunal, Your Lordship.
Under the civil, can't you approach the civil court? Can't you file a suit?
Your Lordship, let the mentality be kept open, Your Lordship.
Not against a private school. How will you reply?
Your Lordship, I have citing some judgment, Your Lordship.
And where is the school?
School is Balipara, Assam.
Where in the array of parties? Where is the school?
School is Balipara.
In the array of parties, where is the school? Which respondent?
Oh, Your Lordship. Respondent number 5 has passed the impugn order.
So, Muzumdar, you know whom to make a party.
I made a GP of the party, Your Lordship.
GB is the school. Headmaster is the school. Which is the legal entity?
Oh, Your Lordship. Should be represented. I may be allowed to correct it, Your Lordship.
You think over. We are not very keen in entertaining this.
Let it come on.
We are not. We will not say anything on marriage. You may have a good case, but not a case for writ petition. Oh, Sri R. Muzumdar, you take instruction.
I may be allowed to correct.
You take instruction. We are not allowed to correct like this.
Regarding mentality, Your Lordship, I will.
Sri R. Muzumdar prays for and is granted a week's time to obtain instruction. Please, Dr. Ravi. Yes, sir. Yes.
Third round of litigation, Malab. The year 99, Boruland Autonomous Council constituted new district secondary to the advisory board. They had intended to build up all the second group of LP and MD schools. There are some advertisement has been issued by the petitioners along with some other persons submitted their application. There are more than 1,000 teachers has been appointed in the year 99. There are in the year 2011, that the concerned government has found that on the ground of suspicion that the appointment is doubtful and that their services has been terminated. There's almost 1,000 teachers has been granted from
You are challenging termination orders.
no, my lord, not I'm challenging the examination order, but my lord, attaining the examination order, my lord, they have filed a weak petition before this single bench is after my lord, and the weak petition has been dismissed, my lord, by a common order. Thereafter, they have approached the division bench. And my
That
lord,
was in 13.
my lord,
That was in 2013.
13, my lord.
Now what is your problem now?
I will explain the my lord that the consequences, my lord. Now, during the course of hearing, my lord, that the government lordship will find a
Sir Das, this is a motion. You come to the point. This is not a final hearing.
yes,
Then you need to explain every fact. Why are you here?
yes, my lord. That because my lord that they have my lord, the government has adopted a policy, my lord, and they have submitted during the course of hearing those teachers, my lord, who are my lord receiving salary up to 2006, their service would be my lord, and their termination order will be withdrawn, and they will be reinstated, and their services will be reinstated and not regularized. Thereafter, my lord, that we have my lord, that the order has been communicated, they have my lord, verified, my lord, our document has been, our report has been submitted, and we are getting my lord, regular salary up to 2010.
Mm.
My lord, all other similarly situated teachers, my lord, their services has been my lord, regularized, and they are my lord, getting the salary, my lord. But we, my lord, our my lord, the termination order has not been withdrawn, my lord.
You are left out.
My lord,
You are left out.
my lord, we have
That is your grievance.
getting the
I think one matter we have dealt
Day before yesterday.
before yesterday.
Yes, sir. And here, Lordship, the REIT appeal was in with regard to the termination made.
Are you working working in the meantime?
my lord.
You're not working. You're not adjusted anywhere as tutor or anything.
Yes.
As tutor, you're working.
No, because we have been terminated, my lord. Thereafter, my lord, we have not been paid.
Lordship may kindly see the prayer at page 29. They are challenging the termination order of 2011 and 2010. And the REIT appeal decision was with regard to the 2006 termination, Lordship.
No, this is not a prayer, my lord. Not a prayer.
What format prayer? We are praying for withdrawal of the termination order.
Yes, my lord, our termination has been withdrawn in person the policy that has been formulated and adopted by the district. Our termination
I don't think you have structured this petition properly.
because they have very clearly submitted their that the police those persons
Is this how you structure your prayer?
because our thereafter our so they have withdrawn the transition order of all other
Will you pray for setting aside a termination?
termination thereafter reinstatement and other
So thus, listen to the court. Will your prayer be for setting aside a termination? If you say that there is a policy decision to withdraw, it is the domain of the authorities. Your prayer should be a mandamus, a nature of mandamus, directing them to act upon the policy to withdraw. You are not challenging the termination. You said they have already taken a policy to withdraw. So why should we enter into the merits of the aspect of termination of service?
they can verify because they have already submitted the document. I am annexing the receipt.
Well, issue notice, not you should structure your expedition properly, Mr. Das. Third, the BK Das, Learned Counsel for the petitioners. The petitioners were appointed as assistant teachers in the BTC in the year 1999, which subsequently fell within the territorial limit, boundary territory of the BTC. Full stop. Their orders of termination from service was the subject matter of litigation, whereafter a policy decision was taken, whereafter it has been projected that a policy decision was taken by the BTC to regularize the services of such teachers who had received regular salaries till the month of March 2006. Full stop. Though the petitioners claim to be within the state category, they have complained that their cases have not been considered, whereas the cases of similarly situated persons have been considered under the policy decision. Para to notice, returnable by 4 weeks. Education elementary K Das, MS K Das Learning Council, elementary 1, 1 and 6. Finance,
I'm paying for two.
Nayak 2, B Chaudhary 3, 4, 5,
7, 8, 9.
5, 7, 8 and 9. 6 to visit our director. That extra copy, sir. Monday. Give extra copies by Monday.
This case, your lordship, I have to take some instruction. Impune order was passed in 2017. Thereafter, what happened, I have to take instruction.
In impute order regarding what?
2017.
Regarding what?
This is the compassionate effort, your lordship. There it was rejected as per clause 1 of the memorandum 1/6/2015.
17 and what were you doing all these years? 6 years on the prayer of Sri R. Mazumdar. Learned counsel for the petition matter and adjourned to be listed after 2 weeks.
All of the petitioners, a lot are working in the Barak Valley Engineering College. Well, the issue here is they were appointed when the college was the starting. They are also a HOD contractor. But my lord, they published an advertisement. And my lord, in that advertisement, we have also participated. We have also submitted our my limited prayer in the petition, my lord. Some weightage for the period, my lord, which we have undergone. And
How long have you served?
my lord, around 3 years now.
3 years. What is the experience?
My lord, because we started off this thing, my lord. This is the interesting point here. But similarly situated persons had approached this honorable court, my lord. My lord would find the order starts at page 59.
Yes.
Relevant is 65.
But
Only thing is that we should not be ousted without leave of this honorable court. And in the meantime, if they can formulate something, my lord, fine.
they should be ousted. Why?
Because we are continue because our
Regular
posts
recruitment.
our posts have also been advertised.
Regular recruitment.
Regular, it's just in the nascent stage.
Let there be regular recruitment. You participate.
We are participating. We have, it's not that we have not, we have submitted. Only thing, my lord, and we have also submitted a representation, my lord, at page 50. Because this was done.
We will not interfere with the recruitment.
My lord will not. My lord did not, my lord. Only thing is that some weightage, my lord. That is what is being considered in.
We may not follow this order.
So there are two orders, my lord, in the similar circumstances. One was passed way back, my lord, before the advertisement was issued in 19.
The UK and Ireland Senior Council, assisted by MS Jutia. Sarah, the petitioners who are 2 in number, the petitioners claim to have appointed on contractual basis as lecturers in the Barak Valley Engineering College, Karimganj,
From 2001.
at the time of its inception. However, presently, a regular recruitment process is on, and the petitioners apprehend that their cases would not be considered in the proper perspective, more particularly when they have already served the college for the last about 3 years and have gained sufficient experience. Sarah, if you notice, returnable by 6 weeks. 3, Das, 1, 2, 3, 4, 5,
The comment copy.
6 extra copies. Sarah, the Senior Counsel for the petitioners pray for an interim order. Though this court is not inclined to pass a blanket order of stay with regard to the recruitment process, comma, it is observed that if the petitioners have filed their, have submitted their candidature for the recruitment process, comma, the and the authorities are going ahead with the state process, comma, the experience gathered by the petitioner may be given some weightage.
No, much.
1-3. Matter 2009 death. And big. Yes.
While providing the charge principal, my lord, the response that ESPSM is provided to the inspector of schools, my lord. And each one is given part of this, but yes, submitted the presentation for the authority, my lord. That's what was said. My humble prayer is that, my lord, is pending, my lord, for the charge of the
You want to become the principal
Yes.
of the amalgamated school.
amalgamate.
Why not others should be considered?
Yes, others should be also considered at the time of considering the other
Now, what do you want now?
director to hear all the eligible persons and pass the appropriate order.
Otherwise, petitioner is not eligible for because he has got graduate skill only in the year 4/8/2016 lottery. As per the act,
But he is qualified. otherwise.
he should have been 12 years experience as a graduate teacher lottery.
How do you overcome this 12 years experience as a graduate teacher?
And the post of principal is not sanctioned as of now because my lord, this post is actually high headmaster of the high school man, which is not sanctioned.
He was supposed to be sanctioned and he used to be promoted and in charge and
I
put
think
as an
it's
in charge
premature.
Yes, Lord.
How can we ask them to sanction a post?
No, I am not asking for sanctioning a post, my lord. I am asking, my lord, yes, they have given the charge inspector of schools, neither to any other teacher of the school. So
Have you filed an application?
yes, I filed an application, my lord. That may be taken into consideration by the state respondent.
But even to hold in a temporary basis, you need to be eligible. That is the law.
In similarly situated cases, my lord, they make some reluctance and they ignore and give also, my lord.
You take instructions to issue notice.
Yes.
Part 3, be broadcast learned counsel for the petitioner who by means of this application has prayed for a direction to allow him to hold charge of the post of principal.
In charge.
Hold charge in charge again.
Yes.
Hold charge of the post of principal of the Dr. Zakir Hussain Higher Secondary School. Full stop. The case projected is that the petitioner was initially working as an assistant teacher in the Dr. Zakir Hussain AME Madrasa in the Kamrup district, which, however, was amalgamated, upgraded to an higher secondary school in the year 2022. And the present name is Dr. Zakir Hussain Higher Secondary School. Full stop. He submits that since the post of principal has not been sanctioned by the government, the charge has been handed over to the inspector of schools, KDC. Full stop. The petitioner's case is that since he is eligible, he may be considered for allowing him to hold the charge of the state post, which is yet to be sanctioned. Issue notice returnable by 4 weeks. All the respondents?
Yes, yes, Lord.
1, 2, by Monday. Copies by Monday. Yes,
Okay.
next. Madam, what is this? Compassionate. 2004 or 14?
Four, my lord.
Four.
There's a delay of 14 years. I have finished the death certificate, my lord, at page 14, page 11. My lord, the case was rejected without assigning any reason.
Doesn't matter. From 9, what are you doing?
My lord, it was told before, my lord.
Sorry. No, we're rejecting this. We're rejecting this. I mean, I will reject police data. Same lines of collector as be Chaudhary. Petitioner.
My lord, I will allow it to be liberty, my lord, because
Liberty what?
I'll explain the grounds, my lord, of my lord delay, my lord. Maybe some, my lord.
Heard MSSB Chaudhary, Learned Counsel for the petition. Also heard MSD Das Verma, the Learned State Council, as well as Sri A. Fukan, Learned Standing Council, Elementary Education Department. Could prepare the case relates to a claim for appointment on compassionate ground. However, this court has seen that the death of the death of the husband of the death of the government employee was in the year 2004, and the rejection was in the year 2009. Full stop. This court, the in the opinion of this court, are the equitable jurisdiction of this court cannot be invoked, wherein there is an inordinate delay of about 2 decades. Full stop. Where at this stage, the learned counsel for the petitioner begs to withdraw this petition with the liberty to explain the delay. Full stop. Para. The petition accordingly stands withdrawn with liberty. Full stop. It is, however, made clear that unless the delay is properly explained, this court may not be inclined to have another review engineer. Huh? 40? Absolutely. Yes, yes, what is this?
We have filed a 04 2020, which order was passed on 09 September 2020. And this similar suspended petition was filed in WPC 1051 of 2020, which order was allowed and disposed on 35 2021. Lordship, the respondent did not comply with our order. The, order dated 0909 of 2020. Besides, we have given them the representation. And
Where is the order?
Lordship, page 30.
3.2.
3.
Which is the what is the operative portion?
Lordship, last paragraph. Accordingly, on consequences with this writ petition is disposed of directing the respondent that the case of the petition.
Accordingly, on consequences, consensus.
Consensus, this writ petition is disposed of directing the respondent that the case of the petitioner herein shall be covered by the order dated 35/2022, passed in WPC 1051 of 2020.
What was the direction?
It is, Lordship, the last sentence, it is made clear that the regularization of the petitioner shall be done in the terms of the office memorandum dated 0203 of 2016.
Correct.
And besides, we have given them the representation on 15/11/2022, which is in page number 34,
And we have given them the reminder also in 0805 of 2020. Lordship would noted
Where is the, madam, where is the earlier order of
page
because
25.
25? What was the directions in that order? Come to page 28.
Lordship, point number 6. In the view of the
Okay, we understood. Or MS as well, learned counsel for the petitioners who, by means of this petition, has complained about non-compliance of the directions contained in the order dated 9/9/2022 passed by this court in WPC 5048 of 2022. The learned counsel has referred to the state order wherein there was a direction for consideration of the case of the petitioners for regularization of their service in terms of an office memorandum dated 2/3/2016. Correct? So, the learned counsel has also submitted that representations were submitted before the present incumbent, followed by reminder, in spite of which no action has been taken for compliance of the order in question.
Lordship, contempt is number 610 2003 pending before the Honorable Court. This
Doesn't matter.
matter and the earlier matter came back.
Let us issue notice. Issue notice returnable by forward. Steps for service of notice upon the respondables 1, 2, and 3 be taken by registered post daily. Steps by Monday. Next.
40 matters at next.
Not now. Let them appear. 40. Yes.
I believe it. Only confirmation. My
Which
lord,
order?
order dated 27/5/22, man. Page my lord 10. There are 5 my lord, page 12. For the order dated my lord 27/5, my lord, petitioner was required to file fresh representation within 15 days. And thereafter, my lord, the opposite party was passed.
Page 10. Page 10.
Yes, page 12, my
Where?
the operating part.
Yes.
There are 5.
Representation. Where is your representation?
The next page, my lord, page 30.
No action taken.
7 June 2020.
Action taken or not?
No, man.
Nothing.
Nothing. Thereafter, petitioner also filed another representation on my lord 15/5/23. No step has been taken.
Heard pre-M Islam Learned Counsel for the petitioner who, by means of this application, has complained about non-compliance of the directions contained in the order dated 27/5/2022 passed by this court in WPC 3460/2022. By the aforesaid order, comma, the prayer for regularization of the leave period was directed to be considered. Full stop. The learned counsel submits that representations were also filed for requesting for compliance, which has not been done. Full stop. Dr. Darkini Ake. Survey. As for numbers, how many? One.
Hold it.
Total. That was by Monday.
Monday.
Registered post daily.
Highly obliged.
13 I took 13 की motion नहीं हाँ motion yes what is appointment of professional
Right, my lord. The year, my lord.
Hmm?
The year.
What has happened? No, 17, what has happened? What happened in 2017?
What happened?
Nothing.
No, when was the death? When was the
2009.
de-
9.
when was the death?
Yes, my lord. 9.
Consideration?
My lord, no consider. I consider the people in the
You submitted in 17.
Yes. And 2005 he is a major lordship. He is first
If you
degree
file
exam
after how many years?
in
2009. After 8 years.
8 years. That's not the objective.
and 2005 he has completed graduation lordship. So he is major at the time of the lordship.
Not a fit case. Sorry. We have to dismiss this. For Sri Bhuya, Senate Council, for the petitioner, who by means of this application has prayed for a direction for consideration of the case of the petitioner for appointment on compassionate ground. The petitioner has projected that his father, Ranjit Kumar Rabha, was serving as the head teacher in the Kemere, Kemera LP school in the district of Dhemaji and had died in harness on 27/9/2009. However, the application for appointment on compassionate ground was filed only in the year 2017. This para MS D. Das Burman, the London State Council, further submit that at the time of the death of the father, the petitioner was a major and was eligible. The long delay of 8 years in applying for a consideration for appointment on compassionate ground would defeat, would not be in consonance with the objective of the scheme of compassionate appointment, which is to provide immediate succor to to a family which has lost its only earning member. Making an application after 8 years, would not be in terms of the act, and therefore, in the opinion of the court, no case for interference is made up. According to the revision, tell this thing. No, it is not. Not this one. Which is your matter? It nalage na. Follow nalage. This will not be, you have the instruction.
Yes, Lord.
It was only conditional that if you don't have instruction,
Lord will take up this matter.
we'll have it.
No.
But it not take it, go normally.
Yeah, Lordship.
Just a moment.
Yeah.
Let us have. Yes,
And here, Lordship, what after receiving the notice, Lordship, that here, Lord Morigaon, he has written the letter directly to the registry, Lordship. And, and therefore, Lordship,
now have you filed your affidavit?
that is my fault, Lordship. I couldn't file. I'll file it by Monday, Lordship. But,
Let us file the affidavit.
Yes,
This
yes,
order
yes.
was passed on 10/5.
Yes, Lordship, that was there, Lordship. That, so just
So in advise your client, yes, madam. Come forward.
come, I would have, next time, no have to do.
Yes, it will be not repeated again.
It's not a
Why
question of repeating. You are a responsible officer. You should know what are the procedures, at least get the legal advice. You have your standing counsel. These are court matters, judicial matters. Registry has got nothing to do. You file your affidavit. Will dispense your personal affairs.
Yes, my lord, I
How
apologize.
about
What is your name?
Fully Gogoi.
CEO Morigaon.
I must, in terms of the order dated 10/5/2023, Mr. Chaudhary, we grant some time to file it. In terms of the comma, I must duly Gogoi Bhuya, the district elementary education officer, who is in charge, who is also the in charge deputy inspector of school, Morigaon, is personally present. The officer has, the officer, while tendering her apology, has submitted that she was not aware of the procedure. The apology is accepted and further personal appearance of the officer is dispensed with. Sarah, the assembly learned counsel submits that he would be representing the officer and prays for some time to file the affidavit in opposition. To file the affidavit. Sarah, considering that this case is pending since the year 2017, a week's time is granted to file the affidavit. List this case on 12th of
Yes.
June.
Her name is Buli Goet. It was wrongly written as Buli Gogo in the petition, Lordship. That may be corrected, Lordship. BULI, not BU, Lordship.
Oh. Three, this case has also submitted that the name of the officer is actually Bully, huh? Bully is so three, who is there with you, Mr. Chaudhary? Your name?
SN Ahmed.
Sri S.N. Ahmed, learned counsel, assisting Sri Chaudhary, the senior counsel for the petitioner, is given liberty to make necessary corrections in the cost title regarding the name of the incumbent. Yes.
Her appearance, dispense, Lordship. Oblige you.
One control. Out of the our motion to have or yes, one.
Here I have received an instruction, Lordship. Yes, DP is not yet concluded and he is still in suspension, Lordship. That is my instruction.
You, what is your post?
Actually, my suspension was I was promoted to the post of principal. But after joining the principal, the allegation is that the BS certificate that I submitted to be allowed that is the backlog. So on that ground,
But that proceeding is not yet over.
Not yet over.
Started or not?
Just started, the so-called was issued, but it was not continued.
2019
And did you have periodic review? No.
No review.
Then we allow this.
Yes.
Part 3A Decca Learned Counsel for the petitioner. Also heard 3 Assembly History Learned Training Council, Secondary Education Department, who submits that as per instructions received, comma, the petitioner is still under suspension, and though a DP was initiated in the year 2019, comma, the same has not progressed. Yes. Full stop. Para. 3A Decca Learned Counsel for the petitioner submit that the petitioner was appointed as an assistant graduate teacher in the Badbury Higher Secondary School in the district of Sibsagar by order dated 2/5/1992. Full stop. He had participated in a selection process for the post of principal and was accordingly appointed as the principal of the school on 2/5/2017, which he had joined. Full stop. However, comma, the order of appointment was withdrawn and the and subsequently cancelled. Full stop. The petitioner was thereafter put under suspension by an order dated 21/12/2017, and the so-called notice was itself served after about 18 months on 29/2019. Full stop. The petitioner further submits that though he had replied to the said so-called notice, comma, there is no further progress. Full stop. As recorded above, comma, the history, the learned counsel, understanding counsel has submitted that there is no progress in the departmental proceedings. Full stop. The department has also not filed any affidavit in this case. Full stop. Para. It is a settled law that though suspension is not a penalty and is also, and is only taken recourse to have a departmental proceeding conducted in a fair and transparent manner, and also under certain other conditions, comma, the same cannot be allowed to prolong indefinitely, comma, more so when there is no progress in the departmental proceeding which was initiated in the year 2019 itself. Under the aforesaid facts and circumstances, from this court is of the unhesitant opinion that the order of suspension dated 21 arbitrarily. There is also nothing on record that there has been any application of mine towards extension, towards making a review for extension of the suspension of Dr. Kalam. Yes, in view of the above, this court is of the unhesitant opinion that the order of suspension dated 21/12/2017 cannot be sustained any further, and therefore the same is satisfied. This court, however, makes it clear that no observations have been made with regard to the merits of the allegation as well as the cancellation of the appointment order dated 2/5/2017 as principal, and therefore the reinstatement of the petitioner can only be made to the post of assistant graduate teacher in the school.
Yes.
Great presenter. Yes, next. Enrique, Instructions are there.
Yes, Your Lordship.
File your affidavit.
Your Lordship, in this case, Your Lordship, respondent 7, that is a school managing committee, has ruled, Your Lordship.
Has
Ruled, Your Lordship. Which clearly mention, Your Lordship. I'd like to place this instruction. I have flag marked it, Your Lordship. The relevant portion, Your Lordship.
what is the case about? What is the case
The
about?
case is about, the year 2012, I have been appointed as a second assistant cook.
Who?
Cook, my Dr. Lafayette Lecture. And by way of taking resolution, page number 11 is the by way of that resolution, my lord, I have joined. Thereafter, page 15 is my joining letter, and the staff pattern is made out. Page 18 and 19. Page number 19, my lord, serial number 219. Kalpana Namasudha, my name is here.
Hmm.
In the middle. And I received honorarium.
Hmm.
However, my lord, in this way, I have been working since 2016, my lord. Till now, I have been working. But in the year 2015, my lord, one resolution was taken. After changing the managing committee, one new president of the managing committee was elected, and he taken a resolution and replacing one Palika Namasudha in my place. Accordingly, I have being agreed to that resolution. This court might not state that
State that resolution.
Yes.
Which is the order?
order, my lord, order, my lord, order dated 26/9/2016.
Twenty-six 9.
26/9/2016.
Okay. Are you continuing?
Continuing.
Now, who is for the school managing committee?
Lordship, I'm appearing for SSA, Lord.
Who's for the school management committee?
Yes. Not a I filed a
8 is the beneficiary. Now, what is the position? Are you continuing?
continuing.
Both.
It has been stayed, my lord, by your that order.
Now, if you are continuing, then what is your difficulty? Let somebody else also work. Your-
I'm continuing, my lord. The matter may be disposed of in the light of that impugned that state order. I may be allowed to continue.
No, without adjudication. We don't want to hear Mr. Biswas. Then how do you say that we dispose of? Yes, what do you have to say, Mr. Biswas? You filed your affidavit. What is it? You were selected. What about her? Managed.
Everything is on record, my
Yes, how have you managed? Tell us.
lord. No, my lord.
Tell your learned senior colleague also.
I have been duly selected, my lord. I received honorarium, my lord.
You have the
This is not-
record.
Lordship will kindly see the prayer, Lord.
Hmm.
Lordship, there they have sought for setting aside of the resolution dated 11/7/2015
Hmm.
adopted by the school management committee, Lordship.
Hmm.
Lordship will see the resolution at page number 25. Relevant portion is page 25.
25.
Yes, Lord. Resolution number 3. So it is decided to provide the sanction money in favor of Kalpana Namasudha, who is the repeat petitioner, pro sec. It was asked to newly engage
Palita Namasutra to join her post after getting approval from the authority. At last, the president may so and so lordship. So against this order, this writ petition has been filed. Now, lordship, so far as her salary payment is concerned, lordship, that has also been paid. Lordship will see in the previous page, lordship.
Let us read the entire resolution 3. There are two resolution 3s. Due to excessive numbers of page 25.
Yes, lordship.
Why two resolution 3? I think one is 4 or what?
Yes, due to the numerous numbers of students, the school.
Due to excessive.
Lordship, excessive. Thereafter, with the intervention of the assistant of the school, Sri Gauranga De, one Palita Namasutra, wife of local 50% local land donator, Sri Sushil Namasutra has been forcefully engaged in place of Kalpana Namasutra as a second assistant cook. The president and member secretary were handed over to receive approval from the higher authority. Lordship, on last date, direction was issued to assist the lordship to obtain necessary instruction. So far as my instruction is concerned, lordship, so far as appointment, engagement of cook is concerned, lordship, it is entirely done by the school management.
School management. You don't have much to say.
Lordship, thereafter, my role.
It is decided to provide
I
the
only need
sanctioned
to.
money
Lordship.
to check. It is was asked to European.
And the relevant portion of the OM lordship I have annexed here. What flag mark not? Down below.
Anybody appearing for the school management committee? 7. Service.
Taken.
7 and 8. 7 has filed Wakalatnama. Who is for 7? School management committee. A. J. Bora. J. Bora is your. Who is J. Bora? Seven ওখানে কোন পেরেছে A. Das, Miss A. Das, Mrs. J. Bora. বলে Let me have a look. Let the court have a look. Just move this up here. So Vishwas, you are for the school management committee. 7 or 7. Eight also. 7 also you are appearing. How can you appear? Same day you file two Okarat numbers. What is this kind of practice, Mr. Biswas? You're for the authorities, you're for the beneficiary. What else remains to be decided in this case? That itself is a ground for interference. What is the difference between the authority and the beneficiary? We have to allow this repetition only on that ground. Not a mistake, probably. Matter is pending since when? Since 2016. Affidavit. We are not on both. We are on a different footing altogether. You appear for the school, you appear for the private party also. Whose appointment is put to challenge. You may defend your decision, but not by the same council. You are for the management committee, you are for the person whom we have given the appointment. Matter we are not going to adjourn. Are you getting your salaries? What about response? You cannot even ask you. What about respond by 8?
Yes, my lord, so far I know, my lord, he has not been joined.
You are HR Chaudhary.
Yes.
First HR Chaudhary. Learned counsel for the petitioner. Also heard Sri P. Nayak, learned counsel for the SSA. Sri, as they discussed, do submit that he is appearing for the respondent number 8, comma, a perusal of the record has revealed that the state council has also entered is also appearing for the SP number 7, the school managing committee, and in fact, the names are also reflected in the cause list. Full stop. Whether such practice is in accordance with law is an issue which perhaps will not be taken up for consideration in this case, in view of the fact that in terms of the interim order dated 26/9/2016, comma, the petitioner is stated to have been continuing as an assistant cook, second assistant cook in the 381 number Dakshin Lafasail LP School in the district of Karimganj, Pranam Asylum. The Learned Counsel Sri Chaudhary has also submitted that he is receiving his salaries. There are till now no application for vacation of the interim order has also been filed. Considering the further practice circumstances and the fact that the petitioner is continuing in terms of the interim order, this petition is disposed of by making the interim order. Absolutely. Okay, thank
Now, Lordship, petitioner will work in place of
you. Interim order, we are not saying, interim order may still continue. He was allowed to continue by the interim order.
but he's not sure whether he is getting salary or not.
He says he's getting set.
No, he's not.
He said,
I'm getting my
Right now.
we have recorded. Yes, thank
I have got ticket the order dated whereby my selection of post of president of SNTC was paid. My lord, by virtue of new notification of the QR, my lord, I was elected by the 7th October 2020.
Yes,
The petitioner Milord, it's absolutely Milord, he was approved by the respondent number 5 Milord, inspector of school. Gross violation of the notification Milord, Milord, on 24/6/2016 Milord, and the I filed by my learned friend Milord, not even single whisper Milord, that he is in a paragraph he said he rightfully he was approved, appointed by the authority, whereas admittedly Milord, that notification is absolute violated Milord, and Milord, already on this position Milord, certain guidelines is there in the notice. If the Lordship permits me, I have to take the Lordship kind attention the notification what exactly kindly Milord, the red petition. Red petition page 18 Milord, annexure 1.
red petition.
Yes, Milord. And
Yes.
operative portion Milord, I will take directly page 21 Milord. Here Milord, selection process of president and vice president of SMDC. The inspector of schools, after consultation with the principal, headmaster, and local people, will forward 2 names to the director, secondary education Assam for each president and vice president, with the recommendation of the deputy commissioner within a period of 30 days. After considering the name director, secondary education Assam, will provide the list to the government with its command for selecting single name after comparing data of both the candidates, and then the government will approve the committee. Here, admittedly, Milord, the inspector of school, Milord, before approving the name of the private respondent number 7, Milord, there is no consultation with the principal or headmaster and local people, Milord. No consult, no general meeting was held, Milord. Whereas from principal and local people has to forward 2 names, Milord. Here, Milord, no such formalities, no such guidelines followed, Milord. And Milord, impugn order passed, Milord, without following all these provisions, Milord. Page 26, annex 3. 26, Milord. Annex 3. This is the impugn order passed by respondent number 4, Milord. Only one name here defected, Milord. Private respondent number 7, 1. Iqbal Hussain Majumdar, Milord, president, as president. Admittedly, Milord. Already, Milord, this honorable court has passed judgment, already settled on this position, already reported cases here, Milord. Wherein under similar situation, squarely covered, Milord, under similar situation, this honorable court and found that due to failure to compliance of this notification, Milord, and order passed, Milord. And one of the case also my learned friend represented under similar situation, Milord, in WPC 3302. Though my learned friend objecting here, but he was on my same foot on this matter, Milord, and same observation relying to this honorable court pass order.
Yes,
Milord.
yes, let us have a look.
My lord, I like to place Lordship. And latest notification, Milord. Also.
Where is the order?
That is reported case, Milord, DLP.
Yes.
Yeah.
Yes. Which paragraph?
Justice, I like to take your Lordship. My lord, but the records placed, Milord, from here, Milord.
Page.
My lord, it is page number.
Yes, yes.
Yes. First, second.
Yes, sir.
Yes, Milord. But the records placed before the court today clearly reveals that it is the inspector of schools
Corbett who recommending single name for each of the posts of president and vice president of the
Okay.
secondary school.
Yes, for a department, what you no, no, on the state vacating application. What do you say?
Otherwise, and the approved name only one name is 26 the order, but it has got the approval from the deputy commissioner of the guardian minister.
Now, what is the present notification which is holding the field?
Well,
Is it the notification of 2016 or is it the notification of October 2021?
2016 partially when the modification by 27 October 2020.
That is it. What is the requirement of the new notification?
The only the in place of the director, the deputy commissioner has been made the appointing authority with the approval of the guardian.
Not the appointing authority. Why don't you read it properly, Mr. Kaushik? He is empowered to
He
select.
is empowered to select.
He is not the appointing authority. He can select.
Select.
So if the selection is done by the deputy commissioner, until these rules are put to challenge, how do you interfere? Sorry. Not a case for state. We are not dismissing. Not a case for state. Third,
I have tasted it, not only one hour. In a similar situation,
Nirendra.
yes, this para 6 also like new notification 27/10/21. And final observation para 11.
Where is 24/6/2021?
Annexure 1 of my petition. Page 18.
24/6/2021.
That is 24/6/2016.
No, no. This
Latest
this judgment has taken into consideration 24/6/2021.
Para 6 27/10/21. That is notification.
No, in paragraph 7, guidelines dated this court has gone on to proceed on our erroneous presumption. It is of 21, it is of 16.
24/6/16 para. Then there is no only two notification 24/6/16 and 27/10/21. Para it also 24/6/16. Yeah. Para 10, 11 all discussed.
That name was not approved by the guardian minister. Different.
Admittedly, that the observation
let us pass the order, Mr. Sekar. You put this to challenge. Will interfere.
This that notification also recorded.
Your notification you put to challenge that the facts were different. There was no approval by the guardian minister.
They are repeatedly the guidelines. The 24 only the
Mr. Dekar, there was no approval by the guardian minister. Have you read the judgment? On what consideration the interference was made?
Well, here repeatedly inspector school interfered in this case. Inspector school has himself referred to the name.
We have not understood. What were the consideration before the court?
Can it be on Monday, so that I could satisfy a lot.
We are vacating the interim order. We'll have it on Monday. Whichever day. In view of this notification, we cannot continue. You challenge this notification. What has prevented you from challenging? Notification does not appear to be proper, but until there is a challenge, we will not say anything. We cannot say. We are not required to say anything.
He was selected. He was selected.
Mr. Dekar, we are passing the orders. Please don't interfere now.
Sorry, my lord. But 24/6/16 notification relying he was approved, my lord. Page 36, my lord. That notification.
urge the Jail Learned Council for the applicant who by means of this application has paid for vacation, public alteration, public modification of an order dated 27/5/2022 passed in WPC 351/2022 by the aforesaid order, while notice of motion was issued, an interim order was passed that the respondent number 7 shall not function as the president of the SMDC of the Nimai Chandrapur HS School, Hailakandi. Full stop. The honorable court took into consideration that as per the guidelines, the president of the SMDC should not have a political career, and to demonstrate the same, the petitioner had relied upon a notification dated 14/9/2021, whereby the respondent number 7 was shown to be the state secretary of the Minority Morcha, Assam Pradesh. Para. On the other hand, the concept for the applicant, respondent number 7 has submitted that the earlier notification dated 24/6/2016 governing the field of appointment of president of SMDC has been modified by a notification dated 27/10/2021. So he submits, he submits that the selection and appointment has been done in terms of the state notification, and the notification itself not being subject matter of challenge, the present stay order is liable to be vacated. Para. Per contrast, the Learned Council for the petition, for the opposite party petitioner has submitted that though there is modification of the original notification dated 24/6/2016, the initial process laid down, which requires consultation with the principal headmaster and the local people, cannot be overlooked. Full stop. He further submits that he has further relied upon the cases of so and so reported so and so in support of his submission. Full stop. Para. Three, B. Kaushik, Planning Council of the department submit that you have filed affidavit, that affidavit has not been filed, he would produce the record. Para. This court has noticed that by the subsequent notification dated 27/10/2021, the earlier guidelines contained in the notification dated 24/6/2016 has been modified. Full stop. Even otherwise, the political affiliation has been explained in clause 4 of the original notification that the disqualification would be for any person who had contested any election of the panchayat level, public parliament, public assembly in the last 20 years, which is not the previous case. Full stop. That apart, by in terms of the notification dated 27/10/2021, not only the power of appointment has been vested upon the deputy commissioner, the deputy commissioner is empowered to make the selection of the president and vice president of the SMDC, which is to be approved by the guardian minister. Full stop. Unless the notification is put to challenge, the consequent action of passing the order of appointment of the respondent number 7 pursuant to the state notification cannot be there cannot be any prima facie case for saying an order by which has been passed by in terms of the present notification holding the field. Full stop. Para. This court has also considered the case law relied upon by the Learned Counsel for the opposite party writ petitioner. Full stop. Para. In the case of Azharuddin Supra, the decision was rendered on 9/5/2019 when the present notification dated 27 October 2021 was not even in existence, and the selection made in that case was in terms of the notification of the year 2016 era. In the case of Narendra Kumar Nath, the honorable court had taken into consideration the requirement of the approval of the concerned guardian minister, and the facts are of both the cases are distinguishable. In view of the aforesaid facts and circumstances and the discussions made above, this court is of the opinion that the interim order dated 27/5/2022 passed in the writ petition is liable to be vacated, and accordingly the same stands vacated.
My dear Milord, this matter may, shortage may be given so the entire matter may be heard.
Hello?
Any date, Milord.
File the affidavit.
Yes, let them file affidavit. Milord, they are coming.
In the writ petition, you write the interim order dated so and so being vacated has been vacated today in IA number so and so 2530/2022. Full stop. Sri Dekha, the Learned Counsel for the petitioner, prays for an early date of hearing. Full stop. Para. Sri B. Kaushik, Training Counsel of the department, is directed to file the affidavit, for which he has paid for how much time? 3 weeks time. Full stop. Immediately after exchange of the pleading, the matter may be listed for admission.
Obliged.
An application for vacancy order. Before my language starts, I want to submit it that in the interim matter, if it is matter vacated the entire repetition board, therefore I prefer final disposal of today or any other.
What was the issue?
Okay, in this particular case, the repetitioner has set in an intercommunication letter of the government, whereby the authority has said that PA degree of the petitioner is valid and he may be appointed. That it was communicated by the director, by the Additional Secretary Government of Assam.
So you
That
said
order-
that the matter was settled by this court.
That is right. My submission to be lordship, the PA degree of the petitioner has been challenged by the writ petition.
You are in the writ petition or
No,
which?
no, by the writ petition.
No. We are taking which pay? Which pay? Writ petition or IA?
IL.
Your respond number?
I am respondent number lordship 7.
Yes.
Cases like that, lordship. Page 21.
21.
Page 21. Then order passed by the Honorable Secretary, considering the PA degree of a similarly seated person, same college. I.
Yes.
Lordship, here, the PA degree of lordship respondent number 7 was 6 and 7. Same college, same institution, same year.
5, 4, 22 in WP. What was challenge here?
The PA degree of the respondent number 6 and 7.
Okay.
Degree of PA degree of 7 and present petitioner is the same year, same school, same college, same university.
Yes.
Also will find finding at page 46.
What is it? Yes.
Thus, the point for determination is entered in negative and against the petitioner of the application holding that PA degree of respondent number 6, 7, and 8 is not liable to be declared as invalid.
Okay.
So against that order, the writ appellant has filed writ appeal before the honorable court.
Same petition.
Same petition. Page 49.
154.
Lordship.
Dated
Dated 28th of April 2020.
28, 4, 23. Upheld.
Upheld. Writ petition. Writ appeal has been dismissed. Upheld. Now, Lordship.
Where, please? Please. Okay. Okay.
Now, what has been addressed by them in this particular case, so we will say one thing. The judgment that has been the application number 3214 of 19. 3214 of 19. Lordship, I have pointed out earlier, okay, that the same counsel, Lordship will find page 22.
Yes.
IH Soike was appearing for the petition. This judgment has been passed on 5/4/2020. Concealing the judgment, petition has been filed challenging against the degree of the private respondent by the same advocate, same counsel, concealing the same judgment. I am not submitting, he will submit.
We will come to you. There will be some implication. Let us see. We are hearing.
This petition has been moved by the petitioner, same council. This order has been passed before the interim order has been passed by the single bench on 5/4/2022. This interim order has been passed
10-8.
10/8/2022. Earlier order is 5/4/2022. I am pointing out because this order has been conceived in the earlier judgment.
No, had it been pertaining to the same
issue, same text.
same person, it's not the same person.
It's not same person.
Neither the petitioner is same, neither the respondent is same.
Same.
A different challenge. You may say that the challenge was conclusively determined. Now we are here to hear.
Now, they have filed an objection to my application for vacation only on the ground that as per Rule 40, Section 14 of the NCT Act, the BA college established to be recognized by National Council of Education. Made in Section 14 of the NCT Act.
NCT has appeared here. You are appearing for NCT. Yes.
Section 14.
1-4.
1/4.
Recognition.
Every institution.
One. NCT Act of 1993. 14. Yes.
Every institution offering intending to offer the course of training of teacher education on or after appointed date may, for grant of recognition, amend an application to the regional committee concerned in such form, in such manner as to be determined by the regulation. Determined by the regulation. What they have taken stand that provided that institution offering a course or training and teachers education immediately before appointed day shall be entitled to continue such course training for a period of 6 months if it has made an application for recognition within said period until disposal of application by the regional committee. If it is not recognized also, within 6 months they have to make application. They have further stated that this is not an existing institution on the appointed. So I have prepared a chart regarding. I have prepared a list of dates where Dr. will find. Dr. will find NCT Act was notified on 1795. 4 regional committee has been established on 13/12/95, where I have to make the application. 4 regional committee notified on 6/1/96. NCT regulation notified in the Gazette on 24/2/96. NCT rule notified on 3/12/97. Very important, Lotip. I have passed in 1997 before the rule has been notified. Appointed day is 7/8/95. Lotip, appointed day is relevant for Section 14.
17/8.
17/8/95. Now, Lotip, the application for recognition, it is 6 months, has been extended by National Council of Teachers Education for up to 7/8/1996.
7/8/96.
97.
7/8/97.
Lotip. 18/8/97. Page 59 of the ILO. Page 59. ILO page 59. This is public notice noted by the National Council of Teachers Education. What you will find is third paragraph. Matter has been considered and keeping in view of the difficulties experienced by several institutions, it has been decided to extend the last date of submission of application to August 18, 1997. So last date has been extended up to 1997. This extension order has never been challenged by any person by the present petitioner. This extension order has not been challenged by any person.
Yes.
Lordship, present college has applied for recognition. Lordship, I have Lordship, the Assam University Silchar list of date given recognition on 5/7/96. Applied for recognition on 12/8/97. That is 11th. Applied for recognition to the NCT on 12/8/97 within the period of notice, public notice. And
This
college
give permission. Permission was on 5/7/96. Permission.
5/7/96 at Assam University.
Permission.
Permission. And college applied for recognition to the NCT on
Give
12/8/97
permission.
within the extended period.
Okay. And applied for recognition.
On 12/8/97 within the extended period.
Yes, sir.
And got recognition on 13/1/2000.
Yes.
Lordship, again, I will take you Lordship to section 14.
Yes.
Second paragraph. Provided an institution offering a course or training in teachers' education immediately before appointed date shall be entitled to continue such course or training for the period of 6 months if it has made an application for recognition during the said period until disposal of the application by the regional company. So applied on 12/8/97 and ultimately give recognition on 13/1/2000. So college is allowed to continue the course as section 14.
As?
College has continued the course till dispose the application, and before that before giving the recognition final application we have passed on. Now they have challenged the BA degree on the ground that college at the relevant time was not recognized. Now I again take you Lordship to the judgment passed by the division bench, where division bench has said
49.
Lordship. Lordship will find page 55.
Yes, 55.
Para 8. I have pointed out the judgment. Honorable Supreme Court in a case of demand reported in 1992 SEC observed that many provisions of NCT Act could not be put into operation only after relevant provision of the provision and forms came into prescribe and rules and regulations. In absence of rules and regulations, the Act cannot be enforced. And as the NCT regulation were notified on 3/12/97, it would not be possible for college to apply for recognition during this period, which we are under extended from time to time. So when rules were not framed, the before regional committee has not been constituted, member has not been appointed, regulation has not been framed, there is no question of filing application for recognition. Regulation prescribes how much fees has to pay and the form of application, everything has been notified by the regulation. That regulation, I have already pointed out, that regulation has been notified in the Gazette on 3/12/97. Rules. And that is why, Lordship, without framing rules, Supreme Court has, division bench has already held that without framing rules, no institution can apply for recognition. So, though NCT has actually notified, there is no question of filing application. That is why public notice has been issued by the National Consultation extending the date of filing application. So, BA degree obtained by the petitioner cannot be declared invalid in view of there is no rule, there is no regional committee, nothing. Secondly, Lordship will find on this point, though there is no judgment from this Honorable Court, finally these two judgments has come. Before that, Lordship, the Allahabad High Court has decided the similar issue. By the single bench has decided against the colleges that the regulation has been, act has come into force, and that is why court cannot extend the time for recognition. And division bench has set aside the judgment of the single bench and ultimately upheld the BA degree. I have given the judgment of the Allahabad High Court and as well as the Supreme Court, which has been relied on by the division bench. I have pointed out to the division bench.
It is okay. Not required at this stage.
Page 20 of the Lordship compile. That is a division bench judgment. Acta
This
Shukla.
may not be required now.
No,
Your simple case is that the BA degree which you have obtained, a similar BA degree was the subject matter of challenge in a writ proceeding initiated by a person represented by the same council, and the beneficiary in that was also represented by you. You are aware of the proceeding. It went to this appellate court. Appellate court has also approved your BA degree. And since your present petitioner's BA degree has been obtained from the same college, same year, it should not be, there should not be any defect in it.
Secondly, Lordship,
Some other candidates of the same person.
Understood. No. The council was the same. Council was he was appearing for the beneficiary.
secondly, Lordship will kindly see one thing they have pointed out in the affidavit filed by them, stating that NCT has earlier filed an affidavit that the BA degree obtained before recognition is in. One affidavit has been filed by the
Now we'll have the views of the NCT.
Lordship. No, before that, Lordship, the single bench of the Honorable Court has already discussed regarding the affidavit filed by the NCT. And NCT has thereafter filed a subsequently affidavit, apologized the court that without ascertaining the true facts, their affidavit has been filed, and Lordship has condoned their affidavit. And I will take your Lordship to the
What is the present stand of the NCT?
present stand is Lordship, the BA degree is held. That was the submission before the
Yes,
division
what do you
bench.
say? Instruction? No, you had appeared before the
Division.
in the writ court in the earlier proceedings. This is what college? What is the name of the college? Present college? You said same college, same
BA
same
degree
year.
of 6 and 7 has been challenged. Seven is at the same college.
7 and 10.
Kindly see page 45 of the single bench order. Page 45 of the single bench order.
Yes. Paragraph.
Lordship, paragraph 35. F. Contrary affidavit by NCT in previous proceeding, whether would preclude the NCT from altering their stand in this case. It is not in dispute that contrary stand of the NCT was taken in their affidavit filed in proceeding number Iman Sirajul Ampia and Iman. In the said proceeding, NCT's stand was to the effect that the BA degree granted by the Silchar College of Education prior to 11/8/2003 was invalid. In this regard, NCT had given an explanation that on 11/5/2001, after NCT has refused to get recognition in the state college, concerned file number Iman was closed. Thus, the degree obtained by the student till 2000 was valid. It was further explained that after Silchar College of Education applied for recognition, state application was taken up by different file number Iman, and after finding requisite compliance of the all deficiencies, recognition was granted for the session 2003-2004. And for all purpose, the case of the Silchar College of Education was considered as a new recognition, and all subsequent records were maintained in the state file number Iman. It was stated that the previous file was not concerned by NCT while submitting their affidavit in opposition, for which NCT has tendered unconditional apology. The court is unable to wholly discard the recommendation as unbelievable because of the maxims. Thus, in the peculiar facts and circumstances of the case, the court is inclined to accept the contention of the NCT, and their stand on this present case is held to be acceptable. However, this court hasn't to add that no comments is being made on the affidavit in opposition filed by the NCT in the previous two proceedings. No any opinion whatsoever has been expressed in respect of the judgment and order that were passed by this court in the said two proceedings. Iman. Present decision is rendered to our petitioner respondent number 6, 7, and 8 of the application. So their stand was different in different petition, and NCT has stated. Ultimately, this court has held that BA degree is valid. So that has been affirmed by the division bench. After that,
What about the observation made in paragraph 38? This is not confined, the observation of the learned single judge is not confined to Silchar College of Education. It is the response number 6, 7, and 8. And 7 is from Subhas. And this observation was the subject matter of challenge in the division bench. No, we have understood, but how do you overcome? Has this point been challenged or altered by any superior court? Irrespective of what you have stated in your affidavit, even you have stated something in the affidavit which is detrimental to the petitioner, court has come to a finding that the degree is valid. Now, unless and until you put an you have questioned that finding in a higher court, which in fact was done, and the appellate court has dismissed the appeal. Thereafter, this finding attains finality. Under those circumstances, is it required for a fresh adjudication? Mr. Chaudhary?
Malo, if he has completed the
No, you can respond to him and mainly respond to this part.
the division bench judge.
Single bench
Before
judge.
that, I'll submit that, my lord. The law is settled that a decision rendered in a case is what it decides on the fact, and it does not. It is not the correct exposition of law. There are various citations, my lord, that has come from that my lord, 1901 Queen's versus Latin. That has been followed by the honorable court time. Here in this case, because my lord, my learned friend was attacking my.
No, we are ignoring that part. We are ignoring that part.
In that case, my lord, the facts were not there. He was not instructed. He was not instructed. All those facts which I'll place now are not there in those cases. Without placing the complete facts, a decision has been rendered. And so therefore, that will not guide the decision that your lordship would render in this. I'll come to that, my lord. What are the facts? Firstly, my lord, very minute difference. This is an interpretation of section 14 of the NCTA Act. I'll take your lordship to the expert. These observations in the, my lord, the honorable single judge in the earlier writ petition, that, my lord, the Silchar that is regarding the Silchar College of Education, and thereafter by the division bench, that is on the facts of those cases. The correct facts were not pleaded in those petitions, which I am facing now, my.
No, if the challenge was structured only to question the BA degree from a particular institute in a particular year, only on the issue of recognition.
If the correct exposition of law is placed before Lordship,
But nobody has gone for review or appeal, further appeal.
no, my lord, it will not be required. Your lordship will kindly come to, my lord, because he is relying on that decision. That those decisions, my lord, do not cover our case on facts. And the facts that were placed were not there. Now I'll place the law, my lord, because the law will override anything, my. Your lordship will kindly come to section.
No, unless you make out a case which is factually different, it may be different. But if law has been interpreted, can we go for a new venture to interpret the law?
No, if your lordship comes to
If you say factually different, okay, we can.
it has not enumerated the law.
Difficult for us.
If your lordship kindly reads paragraph 20.
No, you are in your old right. You can say that, but for us it's difficult.
No, my lord, these division bench judgment, because my lord, single bench judgment does not create any problem for your lord.
DB.
My lord, in fact, this order was passed, my lord, by which the impugn which has been impugned with the writ petition, that was passed pursuant to the direction of this honorable court, and the direction of this honorable court was not, my lord, complied with by the observations made that in the light of what this has to be decided, that has not been decided. I'll come to that. First, I'll take your lordship to the section 14 of the NCPA. Because this will be an interpretation, my lord, the section 14 has to be read with section 16 and 17. Section 14 says, may I read it, my lord?
Yes.
Recognition of institutions offering course of training in teacher education. Every institution offering or intending to offer a course or training in teacher education on or after the appointed day may, for the grant of recognition under this Act, make an application to the regional committee concerned in such form and in such manner as may be determined by regulation. My lord, I'll repeat, every institution offering or intending to offer a course. So, my lord, institution can be two types. One is already existing, one is which may in future come into existence.
No, institution may be there, they offer, the course is to be offered.
Course has to be offered. Now, proviso, your lord, kindly read. Provided that an institution offering a course or training in teacher education immediately before the appointed day, this is important. That means an existing institution.
Correct.
An institution offering a course or training in teacher education immediately before the appointed day shall be entitled to continue such course or training for a period of 6 months if it has made an application for recognition within the said period and until the disposal of the application by the regional committee. Therefore, my lord, this time has been granted not to the institutions which will come in future. This is only granted to the institutions which are in existence. The institution from which he has come, that was not in existence at this point of time. Therefore, this proviso will not help him. And subsequent extension that my learned friend has relied on, that will also not be in aid to him, because that institution was not in existence.
When was the institute again?
The institute was, my lord, 31/12/1995, the institution. 31st of December 1995.
95.
Thank you.
And the regulations are of?
The Act came into effect from, my lord, 17/8/1995. Appointed. That is the appointed.
And when was it notified?
1/7/1995.
17.
I have given the list of
You said 31/12/1985 the college came into being.
Yes.
Subhas College. Subhas.
My lord, earlier the name was
Substitution.
Hailakandi.
substitution college of
Earlier the
research
name was Hailakandi
B.Ed College.
Institute, B.Ed College, and it was renamed as Dr. Substitution Institute of Education.
This chart I have mentioned.
That I do not have to refer here.
Later, Sasibhushan. Okay, then what are you trying to?
What I am trying to, my lord, improve your lordship is that since this institute was not in existence
The new institute.
on that date, therefore this extension of time for a period of 6 months is from the date of establishment may be all right, but the extension that has come, my lord, subsequently up to 1997, my lord, does not give him any benefit. After he has, my lord, the institute has applied for recognition. That is the date, my lord. Date is 12/8/1997. They have applied.
No, but we can resolve the matter. Have the instruction from Mr. What is the take of call of NCT on the
That is necessary. my lord.
issue of recognition? That will cleanse the
That
issue.
is necessary.
Lordship can you see section 14 again I'm pointing out.
Now we'll come to you. Regarding interpretation will come. But this is a factual thing. You get the information.
In fact, my lord,
It's
earlier
a minimum instructions. Get a email, get a WhatsApp. You ask whether this institution has been recognized. Is it recognized when? They'll cleanse the matter.
recognition came in, my lord, in 2000. 13, 2001, my lord, recognition.
And the degree was obtained when?
1997, 96, 97, 4.
What is your take? How? What will happen to this degree? As per the, you are the authority, aren't you? What is your call? How do you treat this degree? So how do you treat these persons who are institutes or units? Hmm?
In fact, my lord, the affidavit that has been filed in the other case, that, my lord, I have annexed in the affidavit of opposition against the, my lord, IA. If your lordship reads that, I think, my lord, that like
Other cases, there are two cases.
in the IA, my
I they have
of the there, my lord, the affidavit filed in the, my lord, the another case, Vision, they have stated, my lord, the B.Ed degree obtained prior to 15/6/2001 is not a valid degree. The Eastern Regional Committee NCTA grants recognition to Dr. Shashibhushan Institute of Education. This is particular, and, my lord, the apology is not with respect to, my lord, this affidavit. It was established, the recognition was granted on 15/6/2021. The respondent number is going to obtain B.Ed degree in the year 1997, and the certificate issued by the University of 4/4/2000, which is prior to the recognition of the NCT. So therefore, my lord, it is not valid. That is their stand, their stand. Your lordship can be CDF at page 12 of the our objection to the act. Even then, my lord, your lordship may have their instruction from my learned friend.
Objection is filed where? In the
That
IA?
is filed in, my lord, in another region.
No, no.
That is in, my lord, in the objection of the petitioner in IA. We have stated it to be affidavit in opposition.
When was the objection filed?
That was filed on 29/5/2020.
It's not on record. 29.5 is not on record.
Yeah.
Now we'll do one thing. We would like to have him take the instruction. But we are not, we're having this IA still alive. We'll consider that IA. When we consider the retribution, that's a different matter. But IA will consider. You get the instructions. Next Friday. 5 to 8. We can have it on 12. Have it on Monday. But to bring the instruction Monday. Third, Sri S.K. Goswami learned counsel for the applicant public record number 7. Also heard Sri M.K. Chaudhary learned senior counsel assisted by I.H. Dakia for the opposite party petition. Full stop. Para. This IA has been filed for vacation, public modification, public alteration of the expert order, expert interim order dated 10/8/2022. Full stop. While Sri Goswami, the learned counsel for the applicant, has submitted that the issue in question has been conclusively decided by judicial pronouncements, including the writ appellate court, the Chaudhary, the learned senior counsel for the opposite party petitioner, submit that the facts are distinguishable. He further submits that in the earlier proceedings, the primary contention was a degree from the Silchar College of Education, whereas in the instant case, the college in question is the erstwhile Hailakandi College of Education and presently known as the Shashi Bhushan College of Education. Dr. Shashi Bhushan College of Education. As regards the senior counsel also submits that though an observation has been made by the learned single judge in the earlier in the writ proceedings mentioned in the writ proceedings relied upon by the applicant in paragraph 38 regarding validity of a degree of a B.Ed degree from the college in question, he submits that the said observation was made after a detailed discussion only regarding the Silchar College of Education. Para. Your name? M.H. Borbe. N.H. Borbe. Standing counsel. NCT submits that he is yet to receive the complete instruction. Para. This court is also of the opinion that the stand of the NCT would be relevant to decide the issue arising for adjudication in the instant case. In the interest of justice, place this case on 12/6/2023 to enable Sri Borbe to obtain the instruction. That will be done. The office may also tag the objection filed in the IA in the court file.
Interim order.
Interim order passed earlier is extended till the next date of this. Well, it's a status quo.
I
What?
am serving as principal for the last 2 years.
It was not continued after that.
You otherwise you have a B.Ed degree.
Yes, ma'am. My degree is not a question.
Now in the selection, he scored more. He was
He
found more suitable. and you're questioning the eligibility.
No, in fact, my lord, he was first in selection. I was in the third, and their degrees were not valid. Therefore, I was.
That is it.
Therefore, I was appointed.
Directly signed number one.
The government took the decision that these are not valid initially. Now they are taking a U-turn. The same my lord election tariff. And that too, my lord, we are doing the observation on
Let us see. You bring this.
It is also not correct that Constitution Institute was not discussed. That single bench has discussed Constitution Institute for number 8.
8 is also from Constitution. 7 and 8. 6 is from
Service appointed.
You want to leave the court? Or
My lord, I would go for checkup.
your colleague will be there. Why are you worrying? Well, pass orders, don't worry. Ask somebody to be there. You need not be there. Okay. Item number? No, this one. Yes, what is this?
1/7 notice on last second also directed the DO and DI to produce the original record of the selection topic. That was really the year 5 and 6. But the present DO has stated that original records were they were unable to check out the original record.
The records indicated are not produced in the next year.
And if they and the director was that if they cannot produce the original record, they were to pursue the
No, not the original production of the record.
record.
Records. The original has not been, the term original has not been used, but you have some instructions.
Yes, yes.
What do you, who's for the petitioner? Name? R. Islam UK Nair. R. Islam was here. Rafiqul Islam UK Nair. They're not interested in this matter. Even on the last occasion, nobody was there. What is the subject matter?
Subject notice that the petitioner had changed the appointment of the Responder 5 as a grade 4 employee to say, and his allegation is that Responder 5 was given more marks than the petitioner in the experience column.
Is there any interim order?
No, there's no interim order. But Responder 5 is still working.
5. Mr. Who is appearing for responder number 5? Let us close this matter.
Yes, no. Let us close it. Otherwise, also notice that Responder 5 has given.
None appears for the petitioner on call, whereas the department is represented by the SMPC, the Learned Standing Council. Put up. The responder number 7, is it? Or 5?
5.
5. For the responder number 5, who's your name? H. Burwa. Learned Council has appeared. Put up. There. This court. When this matter was taken up on the last occasion, that is 17/5/2023, there was no representation on behalf of the petitioner. However, this court had directed production of the record, which has been done today by Sri Tisti, along with a forwarding letter, which is marked to the Learned Council. The selection and appointment of the responder number 5 to the post of grade 4 in the Tilpukuri ME School, Sivsagar is the subject matter of challenge. Full stop. Allegations of there being discrepancies in the marking pattern has been made. Full stop. However, from the photocopies of the concerned documents, it appears that a standard method was followed and thereby no prima facie illegality has been seen. In any case, this matter is pending since the year 2016 and response number 5 is still in service. In that way of the matter, to prima facie, this court is of the view that the same does not warrant any interference, in the absence of the counsel for the petitioner, instead of passing an order of dismissal on merit, this case is dismissed for want of prosecution. Copies of the instructions along with the documents produced to the court is made part of the record. Madam, note that
In this case, madam, no, madam. Selection, he has been selected already, madam, by the for my notice.
but it
I
has
have
been
taken steps, madam.
Hmm?
Why don't I do?
till that no steps have been taken. Correspondent was sick. Where is your where is your application?
Headmaster.
Where is your clip? It is meant for listed for that purpose only. That no steps for responsible six has been taken. You have it.
No, madam. Headmaster is not necessary part.
But then you have to tell us.
Yes.
We'll strike out the name
I
of
leave
the
it
headmaster.
strike out.
And what is your instruction?
Otherwise, Lordship, on 02/03/2023, SLC recommended his name, Lord. What a post of grade 4 post.
It's a compassionate appointment.
Yes,
Yes,
compassionate.
Then thereafter,
Yeah, the department has answered. So we
no,
have-
no. Somebody else has been appointed over.
No. Lordship, our case is that
What is the projected case? You are seeking the appointment pursuant to the selection. If the SLC has recommended, why don't you go ahead with the process of appointment?
Madam, in the morning, I have received one letter, madam, from Inspector who advocate for the respondent sent to me. It is written like that. With reference to the subject cited above, I have been honored to inform you that as per minutes of the state level meeting held on 2/3/2023, Hitesh Deka under Nalbari district has elected for appointment as Gate 4 competent. The committee recommended and adjusted the candidate. in
What is
Gate
the date
4
of that
post.
communication?
Communication is 26/5/2023.
Recent communication.
Recent, very recent.
Probably you need to take instructions.
So short
Yes,
date
yes.
maybe. What you did.
So this matter has been listed under the column order in order no step. MS Devi, K. Devi, Learned Counsel for the petitioner submit that the responsible six with regard to whom the office note is there, maybe is not a necessary party and can be struck off. Put off. Accordingly, the responsible six is struck off from the array of parties. Put off there. MS Devi, the learned counsel for the petitioner further submit that as per information received, the our recommendation has been made in favor of the petitioner by the state level committee for appointment on compassionate ground. The communication is dated.
26/5.
Communication is a recent one, dated 25 26/5/2023. Under the same circumstances, this could directory SFTCC, the Learned Standing Council, Elementary Education Department, Secondary Education Department to obtain necessary instructions.
Case was said after forwarding the name by the DLC, SSC did not consider his case, but on the SSC always recommended.
एक पढ़ लेता हूँ मैं के देवी के पास Three, S.R. Barua, the Learned State Council submits that the projection made in this writ petition is that no steps were taken by the SLC of the case of the petitioner regarding consideration for appointment on compassionate ground. However, as per record, the SLC has taken a decision on 2/3/2023, whereby the case of the petitioner has been recommended. That's what
The instruction I have put there says that
and the instruction obtained in this regard has also been placed before this court. Yes. So in terms of who has approached this court with regard to consideration for you give a copy of, you retain this, give a photocopy. पहले छापों को करेगा तब
Let the matter be listed after 2 weeks.
क्या टाइम किसकी क्या पता लगा
It will work. 2 weeks after.
नहीं बोला कि असेंबली बोला क्या लाइन instructions for which he pays for and is granted 3 weeks time. Yes.
Small amount is
Amount means why?
28/4/2023. Because the petitioner was directed to keep all consequences benefits, that is the area salary. Petitioner service was terminated and that was taken by the court. Due review petition, review dismiss, thereafter reinstated service with all benefits.
Yes, have you paid the amount?
My lord, Particularly 2023.
How much amount is there?
Amount is small, 70.
70?
Out of 80,000, 90,000.
Total 77,120.
Is pending. But this matter is also pending since 2016.
And this court has directed already, they have found they will pay the amount. 28 court order. They have
Yes.
issued a court.
Yes, yes. What are you doing? Here from home. The Pegu elementary. Last time you had given on last occasion 28 for you short time.
No, no. Court has observed that they have instructed. That is the instruction that they will pay the amount.
That is it. A short time. Time was given. Make the payments. Otherwise, small amount. Why do you invite trouble?
There is a double reduction regarding tax.
Though this court by order dated 28/4/2023 had recorded the submission made on behalf of the department that the matter would be resolved within 4 weeks, and had also made further observation that pendency of the writ petition shall not be a bar, Sri S.K. Goswami, and counsel for the petitioner submit that till date no amount has been paid. Considering that this writ petition is pending since the year 2016, a last opportunity of 3 weeks is granted to the Pegu learned standing council, elementary education department. List on will fix a date. List on 23rd of June. What is this, Mr. Saike?
Case against the order of amalgamation of the present school with another two high schools. Let that case. Notary is the case number 24, man. Case 24. I am directed to say the Governor of Assam wishes to amalgamate the following schools with Ayabari High School under the Shiksha Kshetra. For amalgamation of the schools which are located in state campus.
Your two contentions, Mr. Saike. First contention is that both the schools are not in the same campus.
Not campus, not
Number two, the enrollment is much more, which is required under the OM.
Yes.
These are your two grounds, principal grounds.
Number 3 ground, my lord, Ayabari High School is 15 kilometers away from my school. And there is a river, Putimari river. How the students will go, my lord? To the,
River, there is no bridge.
my lord, river 15 kilometers away from the present school.
No, you
And
said there is a bridge.
There is no bridge.
No bridge.
They have to go by boat. Absurd order, my lord, because before amalgamation, my lord, at least I should be heard as per the judgment of the learned single judge. And one judgment has been passed long back that the agreed teacher should be heard first. And we are the agreed teacher. And we submitted the petition, we were never heard. And the memorandum itself is, my lord, violated by themselves.
Mr. Bora, what do you say?
Page 19. Let me pick up the office
But there is
memorandum.
no stay order.
The stay order is there. There is stay order.
Stay order is there.
Yes.
Which order?
Stay order was passed long back.
21/9/18. 21/9/18.
Yes, yes, 21/9/80.
19/1/2018 is the impugned order.
Yes.
Let us have a first look at the impugned order 19/1/2018.
On 21/9/18.
19/1/2018. Let us see the impugned order first.
Page 24.
24. Yes. What is the name of your school?
My name of my school is Poladar Bangalipara ME School.
ME School.
Hello.
Petition.
Bangalipara ME School.
Okay.
And there are above.
Poladar Bangalipara High School.
Yes.
You are thought to be amalgamated with this.
With the Ayabari High School.
This is the school.
And I have made this statement that
Ayabari.
School is not in the campus. It is paragraph 20, paragraph 14 and 15. Page 9.
Yes, what is which violation is of the office memorandum? Which part is violated?
Page 19, madam.
Yes.
Of the memorandum, page 19.
19/19.
19.
Yes.
Paragraph, my lord, paragraph 10. The ME school has 4 enrollment, that is less than 50 students in each class. Then the ME school may be merged with the nearby high school. Now we have got more than more than 300. Page 15. 368 students.
15.
Yeah, yes, 15.
Page 15. And a class wise,
That's why they have given that. They have given.
you should not have less than 15. Here you have 80, 46, 59. Yes. Okay. And this is one violation. Then what is the other?
And then, my lord, in their high school also, page 14, there are 272 students. Page 14.
Okay. 14 is guided by which?
In their high school. Rather, Bangalore High School.
Should not exceed baby Mars.
They have violated 40 clause, 10 and 11.
Okay. For high school, I think it's proviso 9 may be applicable. If 2 or more high schools are located within a radius of 2 kilometers, these high schools may merge provided the total number of students do not exceed 40 in each class. Now we have seen that even before the amalgamation, it is more than 40.
Yes, sir.
Then which, so we are not concerned with the high school. What about any other clause in the memorandum regarding ME school?
These 2 important clauses are violated by them.
Now what about the distance? If 2 or more is
I have a high school. I have made this statement in my paragraph 15. Paragraph, my lord. Paragraph 15, 14 and 15. 15 may be similar. That the school managing committee was held on 27/27/18 and decided to suddenly impugn order. That the Ayabari High School is 15 kilometers away from the Poladar Bangalipara ME School. And there is a proximity divide between the 2 schools. And it is not feasible on the part of students and staff of the Poladar Bangalipara ME School to there is a typing mistake. Anyway, It is not.
Yes,
possible.
Mr. Bora. How do you overcome 10?
Got a commission secretary election department. The same time in that the peace memorandum dated 27 September to turn to the last page of the
Memorandum.
that is 27.
Yes.
Yes.
Director concerned with there is an order for calculation for any writing out of the order. The execution public may depend for the government. In the
Now, at this stage, after 4 years, we are not going to send it back or 5 years.
there is a question for every that's why I'm putting.
After 5 years, I'm going to remedy this matter for consideration. These are matters that you should raise at the threshold. After 5 years, just imagine 5 years has been pending in the court. What will the appellate authority do now? Yes. What about the main contention regarding violation of the provisions of clause 10? Are you disputing the fact that the chart of the students given in the petition are not correct? That has not been disputed. We'll allow this. We are not touching the high school aspect.
Only thing is
Mr. Sakya,
order has been
has the high school also come with a separate petition?
The IABD is separate.
No. Has the high school also come on with a separate petition?
Has not come.
Only the ME school. That means high school must have gone there.
High school has not gone. They did not take any steps, did not challenge the order, and the high school is being their own classes in their own campus.
another
High school, they know it very well. They themselves also apply for the impino order or to us. I have met this.
Yes. Art is like counsel for the petition. Also, art three. For the user. Now we are disposing this of user modern training concept. Elementary education department for the secondary education department. Who is for elementary? MS also had training concept elementary education department, as well as Sri U Sharma, training council secondary education department. Sri S Bora has appeared for the BTC. For the S Bora understanding council has appeared for the BTC. Considering the facts and circumstances of the case and the fact that the same is pending since the year 2018 without any affidavit being filed by the contesting respondents, the same is taken up for disposal at the admission stage. The facts projected are that an office memorandum was issued by the education department on the policy of merger of various schools. In the instant case, the relevant clause is clause 10, which is extracted here in below page 19. Clause 10. The petitioners are the office bearers of the school managing committee of the Bolajhar Bangalipara ME school at Tamulpur, in the district of Baksa. In terms of the aforesaid policy decision, comma, an order was issued on page
24, my lord. On 19 January 2018.
on 19 January 2018, whereby the school of the petitioner, along with the Bholajhar Bangalipara High School, were thought to be amalgamated with the Ahiyabadi High School. By drawing the attention of the aforesaid clause of the OM dated 22/9/2016, comma, Sri Saikia, the learned counsel for the petitioners has submitted that to amalgamate an ME school comma, there has to be less than 15 students in each class, and under that condition, comma, the said ME school may be merged with the nearby high school. By referring to the
Yes, 15, my lord.
to the data provided, data regarding number of students in the student and staff in the state school, which has been annexed as Annexure 3 to the writ petition, comma, Sri Saikia, the learned counsel, has submitted that each of the classes have students which is more than the requisite number mentioned in clause 10. Also, for ready reference, comma, the attendance, uh, the data regarding the student in the various classes is expected herein below. Yeah, page 50. The learned counsel for the petitioners also submit that apart from the fact that the number of students in the concerned school do not justify any action of merger, comma, there is another condition that the nearby high school, that the high school has to be in the vicinity. Also, it is submitted that the Ahiyabadi High School is at a distance of
15 kilometers.
15 kilometers, which is separated by which river?
Putimeri.
By the Putimari River, and there is no bridge. Also, the learned counsel for the respondent, however, submit that the impugned decision being an outcome of a policy decision, impugned order, impugned notification being an outcome of a policy decision from the same may not be interfered with by this court. After hearing the parties and on basis of the materials on record, this court has come to the conclusion that the projected facts of the petition have not been controverted by any of the respondents by filing any affidavit, and therefore by the doctrine of non-traverse, the averment made may be deemed to be correct. Even otherwise, this court has noted that the data regarding the students does not justify merger of the school in question with any high school. The policy decision of policy decision published by the notification dated by the OM dated 22/9/2016 with regard to merger of ME school with the nearby high school does not appear to be applicable to the case of the petitioner, both on the issue of number of students and the distance factor. Sarah, please take care. The counsel for the petition at this stage submits that this court, while issuing notice, has passed an interim order dated 21/9/28, which is continuing till date. Sarah, in view of the above, this court is of the opinion that the impugned order, so far as it relates to the merger of the school of the petitioners are concerned, is liable to be interfered with, which is accordingly done. Consequently, the part of the order dated, part of the impugned order dated 19/1/2018 relating to the Holajhar Bangalipara ME school is set aside. The restriction accordingly set allowed. Interim order made absolute. Is accordingly made. 21.
You also under same case.
Same case.
Identical. Similar.
Barkopa. Where is this? Barkopa? 16.
Number of students.
Number of students, yes.
201.
201 is not material. What is material is, it should not be less than 15. Where is this? Barkopa.
The best order is impugned order page 25.
एक ही होगा हाँ? नाम होगा बरकोपा एमई स्कूल इन द डिस्ट्रिक्ट ऑफ कमलपुर नहीं होगा इन द डिस्ट्रिक्ट ऑफ बक्सर फिर जो स्टूडेंट रेशियो था वो पेज 16 and where is the impugned order? 19 January. Is it same date?
Same date.
Same date. Date be same. Borokopa High School, ME school. Here only two schools are. Oh, same.
Same, same.
Ahiyabari.
Yes.
Accepted. Rest, all is everything. Interim order was also there,
Yes, yes,
same date.
yes, my lord, interim order was there.
What is the date of the interim order?
The interim order was there.
24/9.
The order was there.
पहले मैंने interim order कितना था? ये interim order 24/9, हाँ? 28/24/9, 2008. Yes. You can go home to disposal. Friday evening.
Another item is there. I have to make a prayer for 1 week time. Item number 47.
You may go, your junior will be there.
Yes.
You take rest.
Okay.
Item number 22. What is this, Mr. Das?
There, my lord, the petitioner is regarding her participation for last 17 years. The case of the case is that, my lord, in the year 1990, she was appointed as my lord teacher by managing committee at that school, my lord. And during the period of 91-92, my lord, the state government has created 500 posts
Of Hindi
under,
teacher.
my lord, under centrally sponsorship. And one of the posts were, my lord, allotted to that school, my lord, for critical. And petitioner was appointed against that post.
Okay.
And subsequently, my lord, during the 9th plan, my lord, the central government has withdrawn the scheme. And thereafter, to normalize the post, my lord, the planning department, my lord, initiated a process for regularization by screening them. And thereafter, my lord, the earlier 500 posts were abolished with effect from, my lord, 1 till 1999. And 401 posts have been created newly, my lord, to accommodate those teachers. And I am one of the teachers, my lord, and appointed in the same school, my lord, thereafter to the year 2000, which effect from, my lord, but 1 till 1990. However, my lord, out of those 401 teachers, 319 teachers were accommodated in the, my lord, provincial election. And 82 teachers were, my lord, attached to the council. And those 82 teachers were, my lord, allowed to draw fixed scale of pay. And other teachers who were appointed in provincial were allowed, my lord, regular scale of pay. Thereafter, my lord, under the banner of an organization, my lord, of teachers, they have approached the government for, my lord, consideration of some, my lord, benefit. And in the meantime, my lord, in the year 2004, all the 401 posts were permanently retained by the common order.
You want a scale, regular scale of pay now?
No, my lord. Thereafter, my lord, what happened? Some people, my lord, some Hindi teachers approached this honorable court for regular scale of pay.
Yes.
And that was disposed of with a direction to consider, my lord. And in the year 2001, my lord, the commissioner and secretary passed an order, my lord, whereby claim of the all Hindi teachers were rejected, but decided to adjust in future vacant posts, my lord. And accordingly, my lord, in the year 2009, 76 numbers of teachers out of 82 teachers were, my lord, regularized. In the meantime, my lord, in the year 2006, my lord, I have been transferred to, my lord, Kolasol Kasumari High School, which is a provincial high school.
This is same district.
Same district, my lord, by IS. And due to the transfer, my lord, I did not receive my salary since then. And what happened thereafter in the year 2013, my lord, where I am, my lord, serving, that post was, my lord, advertised. And then I approached this honorable court for stay of the, my lord, advertisement and also, my lord, adjustment against that. This honorable court, my lord, I ordered that, my lord, 1/8/2016, dispose of this petition, that is, my lord, case 78 and extra 24, my lord. 11 portion is, my lord, in case 83, my lord. Here, my lord, text has been summarily discussed in second paragraph. It is seen that the respondents in the secondary education department have not denied the fact that the petitioner, along with 82 numbers of teachers,
And in the case of petitioner, he was appointed in Borbeti Girls High School, Nagaon district during his master's. It has also been submitted that in the meanwhile, state Borbeti Girls High School, Nagaon district has been provincialized under provisions of the Assam Act 2011. It is seen from the above that as the petitioner was transferred as her own request from Borbeti Girls High School, Nagaon district, the Central Education Institution to the second sanction post of 115 NDT service from Colasol Customer. A provincialized school by an order dated 2/8/2006 issued by the then Inspector of Schools, Nagaon, was not in conformity with the statutory code with regard to the recruitment of teaching and non-teaching staff in provincialized higher secondary schools of the state. Therefore, the petitioner is not entitled for any salary for the period he served in the state Colasol Customer High School in terms of her illegal transfer order. Since there cannot be any transfer of an incumbent working in a higher educational institution to a provincial state, as government do not give any sanction for any such service. However, as the respondents have not denied the fact that the petitioner is not among the to adopt indicators, have already regularized 76 such indicators working in adult secondary school, like that of the petitioner. The respondents in the secondary education department, particularly the commissioner secretary, secondary education department, is directed to consider the case of the petitioner for regularizing or adjusting her service in any provincial higher secondary. In the post of indicators from a prospective date, in accordance with law, the commissioner secretary, secondary education department, in a period of 90 days from the date of certificate of order, to be submitted by the petitioner to pass a joint order with adjustment or regularization of service of the petitioner in a vacant sanction post of petitioner in higher secondary school as considered earlier for similarly placed 76 adult teachers out of teachers which thereafter the petitioner, my lord,
The additional affidavit has been filed.
my lord,
Additional affidavit filed.
my lord, sir.
We have filed a certificate here, and as per queries of the honorable court, we have replied it, and following the reply, my lord, here, in page number 40 and paragraph 3, ma'am.
Now, what are you seeking, Mr. Das? Now,
My lord, what happened thereafter,
what do you want? Tell us.
my lord, for adjustment and my lord, current and area seller, there is,
Area salary is from which year? Which part? Which?
my lord, there is a direction of return bench, my lord.
No, which from which period?
We actually for the period of with effect from my lord 2006, from which my lord we have entered service in the Colasol Customer Act. But that honorable division bench, my lord, allowed us to get the salary only from the year 2010, from 3 years from the my lord side. And but that salary has also not been released till date.
You were working otherwise.
Yes, my lord. That is reflected in additional affidavit. I am still.
Yes, what about the salary part, Mr. Sharma?
As regards the salary part, in our affidavit, there's paragraph 5, ma'am. With regards to the query regarding regularization of the service of the petitioner, the deponent humbly begs to that the services of the petitioner were regularized, adjusted as Hindi teacher in Palasol Customary High School by order number order dated 27/2022, whichever from 27/2020, and also directed to draw her salary with immediate effect. In this regard, the then inspector of school directed the headmaster of Palasol Customary High School to take necessary action. Accordingly, headmaster of the state school draw and disburse her provisional monthly salary with effect from 27/2020 to 31/10/2020 and applied for the release of her salary in FIN Assam portal on 6/10/2020, seeking approval of the directorate. Accordingly, the proposal of first salary of Timothy Beauty Deka submitted to the government in Fin Assam portal bearing proposal number FFP SC 0915 from this directorate for approval, but government raised objection as there is no specific order from the Honorable Court for regularization of the service of the petitioner. Timothy Beauty Deka is as Hindi teacher at Palastan Asmari High School now.
During vacancy of our
Now, if she is working, why don't you pay the salaries? Regular salaries, current salaries, arrears, you may take a decision, you can have some time, but current salaries, how will he or she survive?
Here, my lord, government has to take decision more over finance also.
you know that it is my lord different.
My lord, it is definitely given for hearing.
This is 24, isn't it? 24 one. Last impute order 24 one.
Thereby, my lord, detected my adjustment only due to not having my step.
But the issue otherwise was adjudicated on 1/8/2016, earlier judgment.
My lord,
Now this rejection is on the basis of what? That
step. And we have my lord, the reply of their affidavit in opposition, but where we have my lord categorically stated that there are two similarly situated cases, my lord. They have been regularized without test, my lord, on 17th April 2017. In terms of order of this honorable court. Similar situation, they have approached this honorable court, and that has been disclosed with a direction to consider their adjustment method. And subsequently, they have been regularized without test. That is, my lord, page 140, next B of my reply to the matter. My order has been passed, my lord, 24th January 2012. Their service has been regularized without
24 January 2017.
Same year, my lord. After 3 months.
You will have this for disposal on a day. Okay. Today it may not be possible.
Right.
Otherwise, reply has been filed by you.
Right.
And 1 to 4 affidavit has been filed. Additional affidavit also you have filed response number 2. Correct? So no need of any more pleading. Tell us 18 matters.
And after our Mojumdar will be there, otherwise we may be out of session night.
He'll be representing the department over Mozumdar.
Our Mojumdar.
Okay, he'll be representing. We can have it after. Our UK does run council for the petitioner, whereas the Department of Secondary Education is represented by Sri U. Sharma. Pleadings are complete and the matter can be taken up for final disposal at the admission stage, which is pending since the year 2018. As requested from our list for admission hearing on after we'll have it on 20th of June, the Tuesday. 20 Tuesday. IA for what, Mr. Das?
The IA for including subject. But anyway, on the last occasion, the government responsible was that by the affidavit has not come.
Muzumdar or Muzumdar not there. Mr. Sharma, affidavit.
Yeah.
But affidavit should have been there. His absence we understand, but why, what about the affidavit? Mr. Mohanta for whom?
And for the private sector, my appointment has been challenged. And I am regarding maintainability, I have a question matter. I is the
Appointment is what?
appointment the principal of a particular.
Principal of a school. What is the preliminary objection? What is your
Regarding my
preliminary
lord, you
objection?
kindly see, my lord, I was appointed after 2 years of my appointment, my lord, that has been challenged.
On the
More
ground
than
of ground of delay.
account of delay, not only that, my non-general necessary party, my lord.
Who's not been joined?
He made an allegation against some of the members of the my lord selection board. They are named in the party. The person he selected for his tail number is Krishna's tail number is 3rd, my lord. Even as I go, then there will be a second come and second man, second position, second will come. He's not been made a party. And already he has retired.
So you have retired?
Also, that answer is, if your lordship carries the order.
No, first objection, second objection we can ignore. But you have retired, what fruit will you get?
There is a big fraud. Also, that has been reflected in the court order. Lordship. Kindly carry
But-
the court.
That is, you may be correct, but
Yeah.
what fruit will you get?
I have prayed for dipping the entire
What will you get?
illegality. There is an
Hey,
inquiry
this is not in the interest of public.
There is an inquiry report. Lordship. The inquiry report also. Lordship.
Understood, but
Finding
you
is
should
against
get
this number.
something. We are not discouraging you or saying that this is a frivolous litigation. But if in the meantime you have retired,
This submission was also made on the last question also, but Robert for after getting the record. And that is that it carry
not,
on.
not in this case, we'll decide in some other case. We'll close this. Not in the instance of a person who doesn't have any interest now. This is you have retired, you are not going to get anything. If there was anything consequential benefit or something, then also matters different. Third. And the other one, I have for imprisonment.
Other one, my lord.
I heard the SK Das Planet Council. We are not saying anything on the merits. You may have something very serious. We are not saying and making any comments on the merits. Heard the SK Das Planet Council for the petitioner. Also heard the U Sharma, and standing council, secondary education department. Mr. Bothakur, what is the second one? Also retired.
No, second
No,
one.
second one
I
was
am
we
the
have challenged the inquiry report.
There is
Wherein
an
lordship-
inquiry report made by the deputy commissioner. What is the allegation? There is a one of the female member is not present in the interview.
That we are not going to.
Yes, that will
that will remain.
That will remain, man.
That
Because I
will
am
remain.
checking that. Without
That
hearing
case
me,
lordship, I am the private.
Okay, then you have a chance there. You have a chance there. Your case.
But my prayer is
Understood.
I
Here,
am only a respondent. Suppose also we withdraws the state petition, then my prayer will go. Suppose tomorrow he withdraws the second, then I have.
no, the inquiry report is subject matter of challenge. That will not go automatically.
No,
If you withdraw,
if my learned friend withdraws the second petition,
secondary petition, who is the petitioner?
I am the he is the
Yes, he is challenging what?
inquiry report against her.
That is it. If she withdraws, inquiry report will still remain against her. How can she withdraw?
because without hearing me, without inquiry has made against me, without.
Unless we set aside the inquiry report,
Yes.
and if you are a party there, your interest is
If I withdraw,
protected.
then it will remain.
Okay. Also, you Sharma, Sri T.J. Mahatalana, Senior Counsel, assisted by Gogoi, T. Gogoi, appears for response number 6. Huh? It's 5014 में, huh? The selection and appointment of the respondent number 6 by an order dated 26/7/2017 is the subject matter of challenge. The petitioner, Sri Das, the learned counsel for the petitioner, submits that such appointment has been done in spite of an inquiry report conducted by the Office of the Deputy Commissioner, Goalpara, wherein there has been, wherein anomalies in the selection procedure has been detected, the selection and appointment has been made. Full stop, para. Refuting the aforesaid allegation, Sri Mahanta, Telangana Senior Council, has submitted that in the meantime, Sri Mahanta, the Senior Council for the private respondent has submitted, has raised preliminary objection on the ground of questioning the maintainability on the ground of delay in making the challenge as well as non-gender of necessary parties. He submits that allegations have been made against members of the selection committee without making them party respondents.
So that has been negated by the honorable court by order.
Okay, no, we are not saying anything. Sri U. Sharma, the London Training Council of the department, submits that the selection and appointment has been done by following the due procedure, due process of law. He, however, submits that the inquiry report, that the validity of the inquiry report has been challenged in another restriction 4237/2021 by the present respondent number 6. During the hearing, it has also transpired that the petitioner has in the meantime retired on attaining the age of subordination. This court is of the opinion that without entering into the merits of the dispute, the present challenge ought not to be continued, as the petitioner has retired from service in the meantime. Therefore, without making any observation on the interstate contention made by the rival parties, this petition is closed on the aforesaid ground.
The interlocutor.
In view of the I apologize. According to the एक line लिखा. This court has also noticed that Sri Das, the learned counsel for the petitioner, however, submits that the allegations are of very serious nature. This court has also noted that the issue regarding the seriousness of the allegations, which is a part of the inquiry report and is a subject matter of challenge in WPC 4237/2021, would still be open for adjudication. 24 my question. 24. Yes, the pleadings are over.
Not over. They are not affidavit.
24.
We have filed our.
Who will file affidavit in 24 and you? You are for whom? You are supporting the Mr. Mahanta. File affidavit. Line 24. Though pleadings have been exchanged, though affidavit of position has been filed by the respondent by 11, both the department and the SMDC are yet to file the affidavit of position. List of 4 weeks to enable filing of affidavit of position. It's
On this matter, on the last occasion, the respondent was quite active. And the other matter is that citizens have been left out from provincialization under
Why aren't you filing affidavit? Either you seek more time, you're given time, a short time to file affidavit, and you don't.
2021 lawsuit. They have
And this matter rightly pending since 2019.
Right.
The last order was of March. Enough time was given to you. Higher education,
secondary.
secondary education. But what about the submission that the issue has already been decided by a division bench?
To
Yes, when will you be ready, Mr. Sharma? We'll consider that aspect whether it is covered by a division bench. When? This court, in the order dated 23/3/2023, had recorded the submission of the Learned Standing Council of the department that the issue has already been decided by the Honorable Division Bench in a judgment and order dated 13/11/2019, passed in WA 283/2019. Para MSRDB, Learned Council for the petitioner, submit that the aforesaid issue would be addressed and by which a distinction would be sought to be made with the judgment of the Honorable Division Bench. Para, this for consideration on 28th of June, 20 June, 20. It is on that part. Para, in the meantime, the affidavit in opposition may also be filed by the department.
Right.
26 and 27, you're from home. And 27, who's appearing? Connected matters.
Connected matter.
Challenging what?
They have lordship.
Private respondent is there or what?
No. They paid another old act. Shutdown act. They are paying for it.
Oh, after 17?
Lord.
Is there anything to be decided now? New act has come. Any consideration has to be done under 17 Act.
Then lordship another 2017 act. The process is also going on for regulation. That highly pending before the lordship.
You are ME school teacher.
No lordship. They are the grade 3 and grade 4 employee of the college.
College. Yes, 21. For instruction. He's ready with it.
Instruction is that lordship. The file is still pending lordship. Not attend financial lordship till today. So they are paying for under the 2011 act.
Now, are you ready with the matter? Otherwise, to
Lordship,
argue?
I am ready, Lord. I am ready.
Sri Gogoi, Learned Standing Council, Higher Education Department submits that as per instructions received, the process of provincialization is still going on
Lord.
under the new Act of 2017.
Lord. 2018, Lord.
2018. So, he otherwise submits that he is ready for the matter be taken up for final disposal. On a prayer made on behalf of the petitioner, matter stands adjourned. We listed on we'll have it on 16th of June. 16th. Next.
My lord, in item number 29, my lord, we have filed two interplay applications, my lord. One for paying for improvement, my lord, and another is, my lord, for verification of order.
Clarification.
Yes, my lord. Because of that, this order, my lord, my promotion has not been.
What is the order?
My lord will find, my lord, kindly
Which
find
I-
IA number 905 of 2023. It's a part of item 29, my lord. Take a tick. 905.
My lord, we'll have it in 90.
906 statement there also, my lord will find it.
I have a 905.
905.
Page
Page 22, my lord. Page 22, annexure F, my lord.
what kind of
Operating portion is a page 23, my lord.
yes.
In the last paragraph, my lord, in the interim, it is directed that the final gradation list of statistical assistant of DIET, SCIT headquarter establishment and SCIT Jorat campus under the director of SCIT Assam, issued by the director of SCIT Assam shall remain till the next returnable day.
Yes.
My lord, at present, my lord, I am serving as, my lord, a research assistant, research officer, my lord, and this impugned gradation list has been published after my promotion to the next higher post. Earlier, I was physical assistant, my lord. Thereafter, my lord, I have been promoted, my lord, the post of research assistant, my lord, under the centrally sponsored scheme of research education. So, my lord, and because my name reflected in the petition list as scale number 1, my lord, therefore, my lord, my name has not been considered for promotion. And the petitioner has no grievance against me. My promotion order, my lord, will find at page 21.
Yes, yes. What you we clarify it.
My lord, in my affidavit in opposition, as well as in the IA for impeachment, he has made categorical statements that he have no grievance. In the affidavit in opposition that we have filed to that, we have said we have no grievance. He's
No,
already
we'll maintain this interim order. We'll make it clear that he is not within the ambit of the.
My lord will not make it ambit because why he is not within the ambit? My lord, he is being promoted. There are 3 posts in the cadre. So I may just make one sub. There are 3 posts in the cadre of researchers. One was created long back. That is in the cadre. Thereafter, my lord, 2 more posts were created under a centrally sponsored. Against that 2 created posts, he has been appointed. My grievance in the first petition is in the original post that is there, one LDA was promoted, which I challenge. Then they come up and say that no, we have amalgamated DIET and SCRT, so these issues are coming. He is already promoted against that centrally sponsored scheme. I have no grievance. My lord will only clarify that as he is sponsored against that, whatever benefit he gets from there, he will get. My lord, I can't stop that. In this repetition, I can't stop. So there is no point in impeding him. Just to, my lord, have a
No, without impeding, how do you pass orders?
my lord can clarify that order, my lord,
No,
while
if you're-
considering
at whose instance?
no, while considering that impleading application, my lord say that he need not be impleaded, but this order can be clarified. My lord can record my statement to that.
Where is the implementing application?
My lord 906.
906.
And my lord, my promotion may be considered under this rule. My
That is what he got.
90.
service.
market. What did him get? What did? Third, RM Decca. Learned counsel for the applicant. Also heard. UK Nair, learned senior counsel. Assisted by T. Chakraborty. Learned counsel for the opposite party writ petitioner. One writ petitioner.
One.
Writ petitioner. Full stop. And who's appearing MDB for whom? Who know who? Difficult University. And no, who are you? You don't say the IA. Who? SCRT and Mr. Pegu, elementary. Elementary. Also G Pegu, standing on the elementary.
It is not.
G Pegu, standing on the elementary education, and 3 as Bora, standing on the SCRT. This is a common order in both the IAs. 1905. While IA number 906/2023 has been filed for impugning the applicant as party respondent number 4, IA number 905/2023 has been filed for modification plus vacation plus alteration of the interim order dated 30/11/2022. Full stop. There. The challenge in the connected writ petition is with regard to the final gradation list of statistical assistance of DIET, SCERT, HQ establishment and SCERT, Jorhat under the directorate of SCERT Assam. Full stop. The case of the applicant who has sought implement as well as vacation of the interim order is that though his name appears in the final gradation list, he has been, in the meantime, promoted to the post of research assistant under a centrally sponsored scheme.
That's page 21 of my 90.
Centrally sponsored scheme by an order dated 24th of February 2021, which was even prior to, which was much prior to the interim order
And
dated
publication of that.
30/11/2022. Sri Dhaka, the Learned Council submits that because of the interim order, there is an apprehension of him being deprived of his service benefits, in spite of the fact that he is that his position in the final gradation list was already acted upon, and therefore he has paid for clarification in the aforesaid order. Sri Nair, the Learned Senior Counsel for the petitioner, submits that the issue involved is a serious one, which would require a thorough examination by this court. He, however, fairly submits that he would not object to the extent that any service benefit which would accrue to the petitioner, or accrue to the applicant on by virtue of serving as an assistant, as a research assistant under the centrally sponsored scheme may not be affected by this order. In view of the yes, SCRT. No, here in the IA, you don't have anything. 3 as Bora, any consider SCRT. Submit that necessary clarifications may be issued in the interest. Under the aforesaid facts and circumstances, this court is of the opinion that instead of passing orders of implement of the applicant in the concerned writ petition, interest of justice would be served if an order is passed clarifying the interim order dated 30/11/2022, which has been done in presence of the parties. In view of the above, it is clarified that the interim order dated 30/11/2022 passed in the writ petition shall not affect the service benefit which may accrue to the applicant by who is discharging his service as a research assistant under the centrally sponsored scheme. Both the IAs accordingly shall dispose of. And the other one?
Well, the other one, the affidavit has to come, and the other one.
And this writ petition affidavit?
No, they are-
And in the writ petition you write, the interim order dated has been clarified in IA number 906 of 2023 today. However, it appears that pleadings are yet to be exchanged. Let the matter be listed after 4 weeks to enable exchange of pleadings. And there is one more petition.
That also, my lord, they are fight.
That petition, you filed pleadings. And the other petition, right, list along with WPC 7626/2022.
7/6/2022, that interim order, clarified interim.
It is required to be accepted. The interim order which has been clarified today in IA 906/2023 shall, however, continue till the next stand extended till the next date fixed. You have filed the additional pleadings.
Question 5, reply, and we have also filed an
Additional. Yes, Mr. Gogoi, well,
it is for all 13 children.
who is for the part? other parties?
No, Lord.
Only your lordship department.
For
You said a similarly situated assistant professor under the JIST and Bineshwar Brahma have been given pay protection. Even pay protection. What do you say?
Lordship, because they are elected as per the FPSC or proper procedure.
Not they are not
They
selected.
are not selected by the FPSC. Although Lordship, they at that time of relevant point of time, it was society mode. Their selection was done by the Lordship FPSC. Lordship. In case of petitioner, it is under society mode, not done by the FPSC. Our stand is that Lordship, as because the institute is under the society mode, it was taken over by the government for the notification of 2016 Lordship. From the date of taking over by the government Lordship, they are entitled for seniority.
In fact, your lordship, when we were, it's like this. This is
Now,
like-
when you took over, it was your decision.
Lord.
Can you take a decision which is detrimental to somebody who is absorbed in your department?
Lordship, that
Pay protection is a natural corollary.
they have to appoint Lordship as per the procedure. Lordship. They have not appointed as per the rules and regulations. Lordship.
Procedure
No,
advertisement
no.
was
At
issued.
that time, it was not done by the APSC.
Not done by the FPSC.
So, what you
But
where
Lordship, the person, the petitioner claimed that Lordship, their pay is protected. They are appointed by the selection by the FPSC. Their selection was made by the FPSC.
who
The person, petitioner
pay
claims
your
that who
protected.
pay protected. Lordship. They are selected by the FPSC.
no, but they did not even have the scope to be appointed by the selected by the
No.
APSC.
Now, Lordship, at the relevant point of time also, that person was under society mode. Society mode also, Lordship, the interview was conducted by the FPSC as per 1981 rules.
How were they inducted into service?
Lordship, there by the society itself, they have inducted.
Society with the approval of the director, your lordship, director.
Where is your appointment order?
But Lordship, as per the rules of the 1981 rules, it should be by the commission, Lord, not by the institute.
Their appointment was when?
Lordship,
When was their appointment?
their appointment was
2008, 28, 2009, your lordship posted dated by the government, and your lordship advertisement is dated 12/12/2009, and petitioners were appointed on 4/12/2010. And your lordship,
No, I'm not very clear about what Mr. Gogoi is.
Lord.
What is the society mode of selection?
Lordship, originally that JIST, your Institute of Science and Technology under the society.
Yes.
That institute and Bineshwar Brahma, two institutes, they are under society. They are taken over by the government, Lordship, in 2016. Lord. Not only the institute, the employees also taken over by the
No,
government.
if that is your stand,
Lord.
if it was constituted through a society initially,
Lord.
can,
Society also, Lordship,
no, in that case, can they be faulted upon that?
no, Lordship, at that time, at that point of time, Lordship, when the institute is in the society mode, then also Lordship 1981 rules is applicable. Because the society is also constituted by the government. Lord. Society, Lordship,
Are you intending to say
Sir.
that irrespective of the fact
Lordship,
that their appointment was done at that time when it was in the society mode,
Lordship,
still it should have been done through the APSC,
Lordship,
which
by
was
the
not
commission,
done,
by the commission.
which was not done,
Lord.
and therefore they are not entitled to the pay protection
Lord.
like the others.
Lord.
Others have entered into the service through APSC.
Lordship.
lordship,
We'll
so
clarify
far
that,
as that is concerned, lordship, that's for your lordship. In fact, your lordship, by the same advertisement, 2014 appointments, lordship, two separate sets of appointees were there. Some were technical, some were non-technical. Now, technical were non-technical were appointed, technical were not appointed. When technical were not appointed, your lordship, we came before this honorable court. At that point of time, stand of the government was that since it is in the society mode, your lordship, therefore we cannot appoint them through APSC, although APSC has selected, your lordship. That was the stand of the government, your lordship.
but it was
Now,
negated by
your
the
lordship,
Honorable Court, Lord.
honorable court says that since you have advertised it, selected it, a section was appointed, you appointed.
It was negated, Lord.
And secondly, your lordship, our appointment, your
That
lordship.
is the point we are trying to.
Yes, your lordship. And that's the, your lordship.
Did you have any role in your in the mode of
Lordship,
your
that's what,
entry?
your lordship. We don't have any role, your lordship. Well, it was an advertisement.
If they were at your mercy, how you induct them into the service,
No,
then
Lord.
later on can you say that you are not entitled to pay protection?
No, Lord. The institute which is under
Okay, we'll consider
Lordship, Lord.
pleadings exchange.
Lordship.
Heard three as Botakur learned counsel for the petitioners. Have also heard three. K. Gogoi, the learned training counsel. This is higher education
Higher education, technical education department.
and technical education department. Sarah. Pleadings are complete. And the matter can be taken up for final disposal at the admission stage. With Para. List for admission. When?
On 13th,
No, not immediately.
otherwise they are losing. They are
On 20th,
2-0.
20. The Tuesday. Why on a Tuesday?
Your also another matter is there. Your connected. WPC 5610. That may also
Listed.
not listed.
It is Priyas Botakur further submit that there is a connected matter. WPC
5610 of
5610 of 2022. List along. The state petition may also be listed. The state petition may also be listed along with this petition.
Apply.
Yes, Mr. Borbia, what is this?
My lord, the petitioners are of teachers.
Rock teacher.
When they were appointed lordship at the benches stage, they were appointed lordship. Subsequently, also they are also are provincialized lordship, but they were not appointed. Subsequently, lordship Jivan Chandra Teka's case came lordship, and subsequently they were appointed. But the fact is that lordship at the time of subsequent appointment lordship, they were bound to give the undertaking lordship that they will their services will be accounted under the new pension scheme. So the fact is that lordship, similar circumstances lordship, this honorable court already lordship considered and said that lordship the past services as per Jivan Chandra Teka's findings lordship, the past services of the petitioner of lordship will be counted for pensionary benefit. So I have annexed the judgment lordship by order dated 12/5/2015 in WPC number 4169 of 2009.
Page.
Page lordship 24 lordship is operating protocol. 12/5/2015. And the main operative person lordship at page 31. The view of this honorable court. Para 17 law. Para 17 and 18.
Yes. So yes, Mr. Talia.
Lordship, there have been certain developments because certain matters have been decided regarding the new pension. So the affidavit of the finance department will be required over here. And Lordship,
And page 34 lordship, they already granted similar benefits to those.
Lordship, we'll try to distinguish them. Lordship, the case of the petitioner from the Lordship may grant us 3 weeks time. Lordship, in the meantime, education department.
Case of which year? 2022. Okay, we'll grant sometime.
Yes, Lordship. 3 weeks time, Lordship. Finance.
On the prayer of 3A Chalia and standing council, finance department, matters shall be adjourned by 3 weeks to enable filing of affidavit in
Lordship, in the meantime, the education department can also file their affidavit.
In the meantime, the education department may also file its response.
Date may kindly. Date may kindly. Before
List on 28th of, not 28th, 26th of June.
like. Maybe is and here in this matter lordship, the petitioner was the same matter lordship. The petitioner was when she was appointed lordship, she having the Ratna lordship which is equivalent.
Finance is there again, Mr. Talia. What is this? He had what?
Lordship, and subsequently she has qualified as a graduate teacher. Lordship. She was appointed, but at the time of issuing the appointment order, Lordship, the grade pay was shown as 2400, which is, Lordship, neither the grade pay of intermediate scale or graduate scale. But the claim of the petitioner already petitioner submitted several representations, Lordship, and after considering all aspects, Lordship, the director at page 36, Lordship, the Director of Secondary Education, Lordship, submitted a proposal for approval to the Commissioner, Lordship, but that was not attended till date. Your Lordship may kindly speak page 36.
Yes, what is it?
Lordship, similar to Lordship, I'll file my affidavit because here the grade pay of the petitioner is to be certain. So similar, same date, my lord.
We'll have it same date.
Yes.
Same order, huh? Page 30. Yes.
Hello. Oh, extremely sorry, Lordship. There is another case, Lordship, regarding same grade pay, Lordship. This that may be also list along with
List along with
WPC number 1884
1884.
2022.
Okay.
Hello.
May I please, Your Lordship? Lordship, I am appearing on behalf of Standing Council Health, Mr. D.P. Bora. Due to sudden urgency, he had to leave court.
We'll have some other thing. Next day, Wednesday, on a prayer made on behalf of Sri D.P. Bora and Standing Council Health, matter St. John, to be listed on Wednesday next. Yes. Date, huh? Date. Yes, Madam Mohai Borua, what is there?
My lord, here of last creation, the court has directed the director to investigate that matter.
What is the matter?
My lord, here the name of the school of the petitioner was left behind, and the name of the one school was inscribed twice. So on that reason,
Not followed. It's a
lord,
matter of provincialization.
provincialization,
Your
and
school was selected.
school was selected, but the name of the school of the petitioner was left behind. One name of one school was inscribed twice, and as such we have made an application, and on that basis the deputy commissioner held an inquiry, and on that basis an inquiry was done. I have annexed that document, but on last occasion the court directed to bring for the original record, and the deputy commissioner office as such has brought the original record, on the basis of which, my lord, the order dated 2/5/2023 was passed. And on that basis, my lord, was found that on the basis of inquiry that everything was okay with regard to provincial life. So on 2/5/2023, the court directed an inquiry from the owner, from the office of the DPI why the provincial life process was not done, or what was the steps taken for provincial life.
Yes. Your school is Madhya Kanhara.
My lord, Madhya Kannada, and the name of Paschim Kannada LP was inscribed twice. Even we applied for RTI, in which the corrected name came, but
Understood. Yes.
Some instruction we have received, but we have to receive that record. Kindly find
But the issue appears to be a very simple one.
Madam.
By mistake, name of one school was written twice,
Yes.
and the school of the petitioners were left out. And that part has almost been admitted.
Yes.
When can you get the instructions, madam?
Look, we have received para-wise comments.
You have received.
Yes.
Then
So when is some time to find?
you want to file affidavit?
Yes.
Madam, we can tell you the tentative reasons. The reasons which you have projected is not the reason of your rejection.
Right.
They have rejected on merit.
Right.
They have not found the land sufficient for this school, number one. And after on verification of the original documents, there is no records of land except the trust map.
Page 34 is their record on. Page 34.
You have to file affidavit.
I thought I their record
Ah.
is an enquiry.
S. Gohai Burwa.
Right.
Heard MS S. Gohai Burwa, counsel for the petitioner. Also heard MSN Fukan, Standing Council, Elementary Education Department. While the projection made by the petitioner is that the petitioner school was the school of the petitioner was deprived of from being selected for provincialization under the Act of 2017 on the ground that another school with a similar name was recommended twice, comma, the Parawest comments placed before this court by the learned standing council of the department gives another picture which relates to the eligibility for such provincialization. Full stop para. In the interest of justice, comma, the department is directed to file an affidavit based on the instructions, so that based on the instructions. Full stop. List after 3 weeks or 4 weeks? List after 4 weeks?
Okay.
You have this?
Yes.
Okay.
Keep here.
See?
This is a deep round of petitioner, my lord. Petitioner joined in, he appointed in 1993. Now he is now 50.
1993 joined is what?
Yes, assistant teacher in 5 class high school, my lord. And there is a in 5 class high school services covered by Assam Secondary Education Provincial Rule 1982. There is a provision for junior assistant teacher, pre-university qualification. So at that time he has passed.
Yes, instructions.
Here, graduation in the year of 2016. Here, for provision of new act, plus 89. In our
89.
Yes.
Yes.
The second paragraph, the appointed success and the teacher tutor must have rendered at least 6 years of continuous service as on 1/1/2017 from the date of joining of the concerned gender education institution, which must be on 30/1/2010 or prior to that. Although the petitioner has joined the school prior to 31/12/2010, but he passed EA examination from KK Henry Open University in the year of 2016. Thus, he acquired required qualification from assistant teacher in the year of 2016 only. And he does not fulfill the eligibility criteria of rendering at least 6 years of continuous service as of 1/1.
That is my lord, illegal because I kindly come to me.
Now, the question will arise is that a teacher, an incumbent, to serve as a teacher or tutor.
Now he
Now, one thing, is it required to be required that he should be a graduate?
Yes, sir.
Then how did you allow him to discharge duties?
claim petitioner claim.
He has been recommended by the district scrutiny committee for T-floor method, not for T. Method. For a moment,
Mr. Sharma, the second paragraph which you have read, please let us read again together. The teachers, tutors must have rendered at least 6 years of continuous service as on 17. From the date of joining the venture school, which must be on so and so. And although the teacher joined on 31/12, but he passed BA. What is required? The graduate degree or joining the school on or prior to 31/12/2010? Which is the relevant factor?
Case 115. Section 6 also, my lord, says that if he has requisite qualification, then he may be professionalized as teacher. Otherwise, tutor. Case 116. And 6 years, here he was appointed in 99. Not 30 years. 6 years, my lord. Required 6 years.
No, it's a very small issue involved. Whether it's the continuous service for a particular period or the requirement is there to be a graduate.
Yes, my lord. I have also annexed, my lord. And case
You come back. Okay, Mr. Sharma, we'll grant some time. Come back. When? When? Tell us.
after some time,
No, not sometime today. Next week.
my lord,
On the prayer of Sri U. Sharma, matters in return to enable him to obtain instructions. Put the list on
it's maybe 8 months. Because my lord petitioner is now 56. 30 years of
56. Is
years
it,
old.
what is the retirement age?
60 years.
4 years.
My lord, since
4 years, the High Court will go to Amingaon.
my lord,
He'll argue there.
last year, I probably 30 years of life.
Not 8. We'll have it on 16th.
I'm okay.
Instruction look, I did say which time to file a report. It's a first time after.
On the prayer of Sri SMT
Only thing you wrote is date may be fixed, Your Lordship.
Learned
Otherwise, Your Lordship,
Training Council, School Education Department matters then adjourned by, we'll say to not 1 week, 2 weeks, file it, 2 weeks to enable him to file the affidavit in opposition.
date may be
Sarah,
fixed, Your Lordship.
list on, yes, tell us the date.
15th, Your Lordship.
No, not Thursday, 14th.
14th.
1, 2 weeks, yes, 14th.
Obliged.
Orders. Where is this the partner matter?
Lordship also heard commission matter and there is a direction. May kindly produce the order dated 9/3/2020.
As per direct.
Was to direct the deputy commissioner to pass the restricting order.
It has been done,
Done.
then
Rejected.
rejected.
Yes.
You'd like to challenge this.
Definitely.
In terms of the order dated,
I brought on record my lord with an additional.
this same order.
Yes.
in terms of the order dated 9/3/2023 passed by this court, comma, the Deputy Commissioner Hailakandi has considered the appeal of the petitioner and has disposed of the same
On 12 May.
by order dated 12 May 2023. Full stop. The aforesaid order is brought on record by both the petitioner by filing an additional affidavit as well as by MS Deedas Verman, the London State Council. Full stop. Para. No. He has filed. By Deedas Verman, by placing the same before the court. Full stop. Para. A perusal of the order reveals that the appeal has been rejected and the cancellation order has not been interfered. Full stop. Para. Sri G. Uddin Karapati, counsel for the petitioner, under such circumstances, praise circumstances, submit that the writ petition may be allowed to withdraw with a liberty to challenge the appellate order. Full stop. Para. The aforesaid submission is not opposed in principle by the London State Council. Full stop. Para. Considering the aforesaid facts and circumstances, comma, this writ petition is allowed to be withdrawn. Both these two writ petitions are allowed to be withdrawn, however, with liberty to file afresh by afresh, in which the appellate order dated 12 May 2023 may be put to challenge, if so advised. Why two writ petition?
My lord, earlier we have challenged the suspension order and thereafter cancellation. Same for the
The order was passed in both the writ petitions. The earlier order,
yes, ma'am. Doctor mentioned about both the petitions. In paragraph 3, ma'am.
7 to 2. Yes. It is 42. 42. 43. Take care. Who has filed affidavit in opposition? Rejoinder against which affidavit?
There are some improvements there. The client also give us support.
The additional affidavit. Oh, not rejoinder. You have already filed rejoinder. See, madam, there are two affidavits in opposition. 1 by 3, 4, and 5, which you have replied. 1 by 7, which you have also replied. There is no question of filing a rejoinder now. You can file it. Okay. Your day, MD. MSND. Counsel for the petitioner submits that there are certain developments which he would like to bring on record by filing an additional affidavit. Put the para. Please after 4 weeks to enable filing of such additional 45. Contempt.
Yes, sir. 45. Your Lordship, as per
44
office-
here. 44. 44. What the amount?
Lordship,
Lordship, let the matter come after 10 days. If you have received Lordship, we will probably be.
Okay. Part 3B Purcast Learned Council for the petition. Petition of 3 SMT 60. Learned Council for the
elementary.
no contempt.
আপনি এরিয়া উপর 1 2 3 4 5 6
1, 2, and 3 submit that apart from the fact that even that in spite of the fact that his clients are that few of his clients are no longer in the post, he has got the information that the department has sanctioned an amount of rupees 83,881 and has been sent to the office of the AG on 7 November 2022. Put Kapara, 3B Chakraborty, Learned Council appearing for the response number 5 endorses the aforesaid submission and prays for some time so that this court can be apprised of the development.
with regard to release of commutation of pension. Commutation of pension.
This is for arrears and arrears.
Area seller that is district madam. Commutation of pension is proposal is pending with the AGS.
Apprised of the steps taken by the AG. Put Kapara. How many days? 2 weeks?
Lordship, the commutation application has to be sent forwarded to us, Lordship. That is further not. Let me
It
take
is
it.
forwarded.
Let it come
It is
to
forwarded.
forwarded.
Forwarded. It is in the file. I just did my copy.
Okay,
is there
Lordship,
in the
let
file.
it matter come after week.
List after 2 weeks.
Any date, my lord?
This amount is commutation.
Seller, no,
This is arrears
area,
seller.
that is received. But commutation of pension is not being paid. Yes.
The contempt petition is in respect of which direction?
Commutation of pension is there, madam.
Both the directions. Last one, Purcast, however, submits that only one aspect of the order in question regarding arrears salaries would be taken care of by the appears to be taken care of by the aforesaid submission, whereas the issue of commutation pension is yet to be considered. Full stop. Three, both three, history as well as three, Chakraborty, and counsel for the respondent shall take are granted 2 weeks time to obtain adequate instruction. Yes,
We have already sent a proposal to the finance department and it is presently pending for a finance.
finance, which officer is there? Finance.
Where the department is asking for 4 weeks time to process the claim of the petitioner, madam.
You do it
Sometime, if Lordship may fix this immediately after the vacation. In the meantime,
No, already one of petition for one or is
Um,
already done.
they are asking
the Assembly History, Learned Council appearing for the respondent submits that the proposal has already been forwarded to the finance department. 3H Aliyah, Learned Council for the response number 7. However, prays for some time to finalize the said proposal. Full stop. List after 4 weeks. Contact 4 weeks. Okay, one more matter. Last matter.
and sometimes we have not received any instruction, Lordship. I have already communicated, Lordship. I need some more time.
The order is dated for the 11/21.
Yes, I have
21 matter
4 months time was
for
for passing a picking order because they were.
for
giving-
that. Why are you speaking order?
I can
You
just
need to
remind
apply
your
your
lordship.
mind. If he is entitled, give him the benefit. If he is not entitled, assign reasons.
Criminally situated
only
person
thing is
there
that I have already
Three
communicated with
SMT
the present secretary.
Senate
Earlier,
Council.
Vidya Dore was made a partitioner. He is no longer.
Council for the respondent praise for and is granted further time of 3 weeks to obtain instructions. List after 3 weeks. Lucky or not, right? Quantum matter. Any urgent matter? Which one?
54.
You're raising your hand. This is not a class.
Your Lordship, as your Lordship,
54.
yes, your Lordship.
What is this?
Your Lordship, she is a middle class community, and your Lordship, as per the advertised dated, your Lordship, 15/12/22, your Lordship, she applied for a post, your Lordship, ITI, your Lordship, into electoral engineering post, your Lordship. And thereafter, as per the advertisement, your Lordship, that is on page 21. It was clearly mentioned, your
Now, why
Lordship.
is it listed today? By orders, why? What purpose is it listed today?
Your Lordship, 2 posts have been available, your Lordship, in Gwalpara and Dhemaji, 1 post, your Lordship. And your Lordship, her name has been reflected in the merit list. And thereafter also, she was not allotted her seat, your Lordship. In spite of that, one waiting list named Dipankar Vaidya, he was allotted to her seat, your
Yes,
Lordship.
an instruction. You have been protected by the interim order. Once it has been left vacant.
No, your Lordship, that was partially, your Lordship, because it was clearly mentioned in the last line, your Lordship, if so.
No, not if so. If the seats in the have or not already been filled up.
Not already been filled
If
up, your
there was
Lordship.
already filled up, there was a protection as on that day of the filing of passing of the interim order. If they had taken action prior to that, how can the court protect you?
And your Lordship, one problem is that, your Lordship, because link for online form fill up has been given, your Lordship, from 24th June 2023 to 1st July 2023. And your Lordship, petitioner has not attended any classes, your Lordship, because admission has not given to her, your Lordship. It has not allocated to her, your Lordship, still. Your Lordship, as per the advertisement, it was clearly mentioned, page 21, your Lordship, I would like to take you.
No, let him have the instructions. After instructions, become degree from government.
Your Lordship, the age limit of ITI pass students is minimum 17 years and maximum 25 years. On 1st January 2023, your Lordship, and as per SC/ST additional 3 years as per existing normal polytechnic, your Lordship. And my petitioner, your Lordship, she attained 28, but as per calculation, your Lordship, date of birth 1/1/1995, age calculated as per notification dated, that is 1/1/2023. That is 28 years, 0 months, 0 days, your Lordship. And as per civil cast, 3 years relaxation is there, your Lordship. So she is 25 years, your Lordship.
Yes, you get the instructions. We'll fix the date. Third MSP does.
Legally.
None legal aid counsel for the petition. Who submits that though there was an interim protection, comma, this seats were already filled up.
On Gwalpara 1 and Dhemaji 1 seat is there, your Lordship, and that instruction has to brought up by P. Sahya, whether seat has been filled up or not.
Then you are protected here if not already filled up. If seats are yet to be filled up.
Your Lordship, online form fill up has been.
No, what is the qualification in the interim order is qualified by the expression
Yes, your lordship.
if the seats mentioned above is already not filled up. Now you say that there are 2 seats vacant.
Say
They'll
vac-
keep
vacant
they'll keep
and
those
the
seats vacant.
instruction pertaining to that, your lordship, context, your lordship. Please say.
As the learned standing council, higher education department, however, praised for and is granted 2 weeks time to obtain this process. Put published on 19th, 19th,
Your lordship,
19th of June.
your lordship, date has already been announced, your lordship.
For?
Online application, online application.
When?
Your lordship. 24. 24 June 2023.
19th where every 19th.
Keep your.
My lord, I am having only one matter left, my lord. Only one matter, my lord. That is 63, my lord. So can it be taken, my lord, on the Wednesday? We are having some matter urgency.
What is the urgency?
Sense, my lord. Urgency in a sense, my lord, is regarding the formation of the SMTC, and the SMTC has expired 1 year back. And thereafter, the Inspector of Schools has nominated President and the Vice President in violation of the rule. So our only prayer is to direct the respondent authorities to constitute a committee as per the rule. That's the only thing.
I am paying for the restaurant for 5 and 6. I have finished there was the baby.
The school is suffering.
You file the affidavit. We'll have it next Friday.
Can it be Thursday, my lord?
Thursday we have fixed many methods. 3A declare learned counsel for the respondent was 5 and 6.
5 and 6.
Submit that the affidavit is ready and will be filed shortly. Full stop Sarah. On the other hand, Sri Chaudhary, the learned senior counsel for the petitioner, has expressed urgency. Full stop Sarah. List on Friday night.
The copy of the IA is not
Lordship.
That you
And that's why I'm
Item number 51 and 62, Monday, can it be fixed, lordship? Motion matters.
Monday motion.
Content.
Monday is not possible. Wednesday.
My lord, same here, my lord, item